specifically directed to list it on 4th of December, my lord. Because the accused, this is a case of under section 138 of NII. Accused is the petitioner here and he has already obtained the interim order of stay.
You are for informant.
I'm from the opposite party, complainant.
Just see how can we adjust.
I have attached the order, last order.
Okay, we'll see how can we adjust. Who will adjust? Yes.
Pardon to make you mention, Your Lordship.
Yes.
Lordship, CRLMC, Your Lordship. Your Lordship, your petitioner is seeking for the quashing of the entire proceeding, Your Lordship.
What is the urgency? Give it, we'll see.
Yes, Your Lordship.
Give it to me. Yes. Please raise. Yes.
I may.
Yes.
My lord, CRLMC number 114 of
Yes.
2020.
What do you want? What do you want to tell?
Listing of this.
Give the memos, we'll see how can we adjust. Okay. Yes. Please. Yes.
Item 1 to 6.
Yes.
I mentioned. Item 7 to 15.
May I please your lordship, my lord? My lord, it's serial number 8,
8.
my lord.
Yes.
That advocate on record the over is on ill health condition. Therefore, a short accommodation, my lord.
It will go to. Yes. On request. Yes. Yes. Next.
Item 16 to 25. Item 26 to 37. Item 38 to 45. Item 46 to 51. Item 52 to 57.
Yes.
58 to 64. 65 to 67. 68 to 76.
May I please your lordship. Item number 68, my lord.
68. Yes.
Permitted to withdraw. I have, in this case, I have filed an IA, my lord.
Yes.
Already.
Clerk counsel for the petitioner seeks to withdraw the petition. Yes. Yes.
Obliged, my lord.
77 to 80.
Yes. Start.
Item 1.
May I please your lordship.
Yes.
There are two matters, my lord, in this.
Yeah.
Well, first one is
Matters by the prayer in ceremony. How this two petitions maintainable by
Why have you filed 2 petitions if the prayers are same?
lordship space 6 lordship may kindly
Yes. First item.
file item 4663. There is a my lord page 5. JBFC City Balancer criminal miscase number so directing the Lord and State Court for response of direction to
29/4/2023.
the
No, these prayers are different, bit different.
no, case are different, my lord.
Cost 319.
Item 1. This is 3191
My lord.
and 2663.
My lord.
Yes.
for my lord.
Which one you are referring to?
Page 18, your lordship. The first case.
Page 18, first case. Yes.
The case, the miscase number 142 of 2022, my lord. Then in the second case, my lord. The prayer is.
Yes, what do you want? Let us understand what we exactly. Yes.
Secondly, 5 minutes time is my reliance is in the lift, my lord. Just coming.
But they are, ma'am, please, your lordship. I'm for the Gosala, your lordship. What they are paying, my lord, the learned code will fix a rate, 4 lakh something.
Yes.
My lord.
According to the care and maintenance rules 2017, they paid only 1 lakh some amount, my lord.
Yes.
They have not paid the full amount.
Yes.
First, they paid the actual amount what the learned court will already decided. Thereafter, the person will consider by this honorable court.
What do they ask?
They are saying
Are they
this is an
asking
order
for-
of 2022.
Yes.
They are saying now your lordship may kindly clarify that order.
Because there is a judgment, my lord, they are transporting the cows, my lord.
Huh.
For that reason, the amount was fixed by the 25 for the
Yes.
use of the vehicle.
Yes.
And subsequently, my lord, he has deposited 4 accused persons at the end. So each will pay, my lord, 1 lakh sum more. So one person has deposited, others will not be deposited. my lord.
Yes.
Apart from that, I have taken instruction whether, my lord, after the judgment of your lordships, whether the appeal.
My judgment, I have you read my judgment?
2024 SCC online Orissa 1338.
Read that judgment. That is an exhaustive judgment. I have dealt with all these things.
Well,
I just simply urgent on the request of learned counsel for the petitioner, the matter is urgent. Learned counsel for the petitioner submits that he would look into the judgment of this court and assist the court as to whether they are what is the impact of the said judgment in the present case. Yes,
next week. and-
yes, we'll see. Yes, next.
Good.
Item two, let's say pass, I prefer pass over. let's-
Pass over, okay.
Okay.
Questioning of entered criminal proceeding on the ground of compromise, my lord. The alleged offenses are 498.
Yes, I'll just call them, issue notice, call them.
Stay of.
What happened? They have compromised.
Matter has been compromised, page 23, annexure 3, my lord. That is the wife, affidavit filed by the wife.
Petitioner is the accused. You have not implemented, yes, you
I
have.
have implicated.
How many accused are there?
Only wife, my.
The petitioner is an accused in the FIR number so and so, registered against him by the opposite party number 2 for alleged offences under section so and so so and so. The petitioner has relied upon an affidavit filed by the opposite party number 2 dated. What is the date?
That is, my lord,
No date.
on this, no, these are page.
29
9, 2000.
1 2009
29,
29 9 2023
my lord.
2023. On the ground of compromise, he seeks indulgence of this court for questioning of the affair and issue notice to opposite party number 2 in the interim exam proceeding before so and so state. Yes.
Obliged.
4,
Item 4 and 5 are related. The order is common. Rejection order is common. There are in total 3 applications.
Yes.
On the last occasion, I had submitted that the petitioner in serial item number 4 is the principal accused in a case of possession of disproportionate assets.
Yes.
The case is under investigation. He sought for release of his salary account.
Yes, you got some.
Various accounts are frozen. Only one account, that is the salary account, on the ground that that is the salary account and salary has flown, it seems, from the account statement which is filed along with the affidavit I have filed as
Yes.
Lordship had directed.
I
of
have
the
asked him to get instruction.
instruction
What
that
instruction have you got?
the instruction is that the 2 accounts there were not problem. 3 lakh I think is the outstanding balance. So on these 2 accounts, one is the salary account and the other one is the account of the son who is serving as a doctor under the state government.
Yes.
That is also his salary account. He is not an accused in the case.
Yes.
The only question was relating to the wife, account of the wife of the petitioner, in which the claim, my reasoning is that it is the loan amount which has been
Loan
included,
account, yes.
which has been
That is
included
some
towards
30
income.
36 lakhs or something of that
36,
sort. What have you got?
36 lakh is the balance.
Yes, I understand. it.
And I have mentioned in the affidavit in detail.
Yes,
I have given the loan sanction order and the affidavit and how the
Yes, sir.
and when the amount was transferred to the
loan
account of the wife.
I understood it. Yes.
Right.
Before you submit the copy, I have sent it to the department. So far as I verified the document, your lordship will find, page letter for nothing. First, if the loan is sanctioned in favor of the money is disbursed in favor of the main accused, 86 lakhs loan. Then on 6th August 2022, the main accused transferred 95 lakhs to the accounts of his wife. And after transfer, and the wife is the housewife, and crores of rupees property stands in the name of the wife.
No, those may I on merit, I am not on that. I just tell me whether 86 lakh rupees was the sanction amount,
Sanction loan,
whether that was disbursed at this money has come to this account or not. Simple.
money has come to the account of the main accused.
Ah.
And subsequently, it has been 80 instead of 86 lakhs.
The loan was revealed by the main accused.
Main account.
May-
So
may-
main account
there-
is not the account, now the money is not in the accounts of the main account.
there is a problem in the manner in which he has submitted. The house in questions stands recorded in the name of the wife. It is a joint loan, and the loan is being repaid from the amount of the from that loan account, which is there, the loan statement, everything is filed from there. My only submission is that Lordship may kindly appreciate, they say that it is my income. And 36 lakh I am yet to withdraw.
Page 7 of the affidavit.
I am yet to withdraw.
1 minute. Page 7 of the affidavit. Just see this document.
Sir, page corner, simple.
7. Page 7. Sanction letter.
Sanction letter I got.
Sanction letter. Read it. This appears to be a joint loan account.
Loan account.
Money has been transferred to the account next year.
Yes, anyone, it can go to anybody.
It is the husband account was 86 lakhs,
Hmm.
but subsequently.
When
95
dates you tell me dates.
Dates on, that is the document there. Like,
हाँ
3/6/2022.
3/6.
2022.
Okay.
The first account holders.
Yes.
6 lakh credited.
Hmm.
Then 6/8/2022. Same page.
Yes.
Look, got it.
Yes.
95 lakhs transfer.
95,000.
95 lakhs
Lakh.
was transfer. You are the sub-inspector website.
This is
ଆପଣ କଣ କହିବାକୁ ଦିଅନ୍ତିନି କାହିଁ I failed to understand.
Hmm.
ତାପରେ next page your lordship kindly see the money was next the wife's account.
Hmm.
Your lordship kindly see first page, second page, third page.
Third.
Money was transferred 6 August 2022 to husband account to wife account କୁ ଆସିଲା.
Yes.
95 lakh. Your lordship got it.
Yes.
Thereafter the money 40,000 all total that has been withdrawn to the tune of rupees 63 lakhs. Sorry, 64 lakhs has been withdrawn by the wife.
Hmm.
The loan amount is 86. He transferred 95. That must be some ill-gotten money. And there is flow of account 5 lakh, 6 lakh, 15 lakh se withdraw करछन्ति, wife withdraw करछन्ति. And by this process, by the end of the check period, she withdrew 64 lakhs. Now 22 lakhs will be treated as loan amount. So now balance is 36 lakhs.
What is the disbursal? Bank. What is the extent of disbursal? Out of 86, entire 86.
86 हाँ.
Entire 86 disbursal.
किंतु से 95 पठेले वर्तमान तांको पाके 36 लाख मो हमर हिसाब से जोटा विथड्रॉ करछ तांको डॉक्यूमेंट अनुसार 22 lakhs must be a loan amount. Remaining loan amount which has not been withdrawn by the wife. It is treated as a joint loan.
Yes.
So at this juncture, if you disburse it, now the property stands in the name of the wife and a crores of rupees. Near about 3 crores is the DA amount. She is a sub-inspector of excise. And what will happen to that? I suppose let him keep the property.
What will happen to the bank, the loan account?
Loan account-
Suppose everything is frozen by you,
My lord.
then in that case, the bank will keep on charging the interest.
We are not on frozen. We will not froze. We will not freeze it. Let him, we are on the process of investigation, we have seized it. Let him keep and balance, keep the similar amount of property security or bank guarantee. We will not have an objection. What will happen to the?
Lordship, may I submit, Lordship, rebut just. Lordship, my instruction is that it is an ongoing loan transaction and the construction for the house is
From
going.
your document,
Lordship,
80 from your
Lordship,
document.
Lordship,
Where from 90,
9 lakhs is from his salary account.
95
Salary-
lakhs,
Lordship,
95 lakhs.
95 lakh, Lordship, 86 lakh is the loan amount. And loan is not the only loan. There are also other loans. And my instruction is the other loans too have flowed
Where
to
is that?
this account. Lordship, khali just one submission. Lordship, 9 lakh has been transferred from his own account. And the main question is that the 86 lakh has been taken towards income. And as my learned friend submitted 60 lakh and odd has been withdrawn. And I am required to pay to the bank interest on the total loan amount without taking the amount.
I am only worried about that.
Lordship.
Because suppose you are entangled in this case.
Yes, yes.
The loan account is multiplied, then you will be in a problem.
Lordship,
So,
that is the
reason I
predicament.
want to defreeze the account.
That is
So
the
that
predicament.
public money has to go back to them. That's the whole idea about it. I'm not suggesting anything.
As I was suggesting, I will also indemnify by giving an indemnity bond. That as and when the court will require, I will deposit the amount. Supposing I fail to deposit the amount, 1 minute. 1 minute, 1 minute. Supposing I fail to deposit the amount, then there are recourse available under the law. I will be sent to prison.
No, that's a different story altogether. That's a different story. But the bank, what is the loan amount now? What is,
Loan amount is
have you
undisputedly
paid back the entire loan amount or not?
No,
What is the remaining amount?
Remaining amount as my learned friend submitted 60 lakhs or I have taken up the loan,
Yes.
and the rest loan amount I have not yet utilized.
I'm not utilization. I'm not on utilization. The amount which has been disbursed, have you paid back to
No,
bank or not?
installment was continuing, but it has stopped
Okay,
at
not
to
paid.
this.
You file a reply there. Let us understand. Yes. It is complicated. Yes.
Let's see, out in a few.
Now, he'll file a reply. Give a reply and
then in
give a
that case-
give a practical solution.
Lordship, may I suggest one thing, Lordship? In that case, I will file a 2-page submission note.
Yes, of course. Welcome, sir. Welcome.
Set up poor account, Lordship.
I'll actually, that's what I'm suggesting him. Try to be practical, have a balanced approach, and I'll pass an order so that your interest is protected, his interest is protected. That way. Which Amit Prasad. Amio Prasad.
Keeping the balance at sir, salary account, you will utilize it.
Then balance taro nijo money kaise balance ro.
Contractual employee.
What is the balance amount you tell me?
Huge flow.
What is balance remaining when the day when you frozen the account?
Balance, account rate,
Huh.
that is Omyo Chaudhary.
What is the balance?
Lakhe 10,000.
Then I'll release it. I'll allow the item 5. What is the account number?
That was salary account.
He's not an accused?
No, not an accused.
He's
No.
not. Right.
FIR ଦେଇଛି ମୁଁ FIR ବି ଦେଇଛି.
Verify the account number. HDFC account or SBI account? तो बाकी जो दिया है कुछ करने देखना लोग डिटेल करके account number. Huh?
Likely.
The likelihood to and which account you are talking about? Account number? HDFC bank account and SBI account. Two things you have said. In the
Omyo Prasad Chaudhary, that is account number.
no, that is the criminal MC number 241 of 2024. Isn't it? 241 2024. Come to the prayer. Prayer. Yes. You have referred to 2 account number. Which one? Tell the account.
Account number of HDFC SB account.
That is P288 79 37161.
How ଟିକେ ଆଜ୍ଞା lordship ଏକା ସାଙ୍ଗରେ କରିବେ ମୁଁ instruction ନେଇକି
Confusion.
ଥାଉ.
Yes.
Item through the password.
Password then 2 o'clock. Yes, next.
6.
Don't jump in between.
But another-
You know some discipline is there.
Another matter.
Adjournment.
ନା ଦିଟା ବେଳକୁ ଏଇଟା ଆର୍ଜନ ଆଉ ଗୋଟେ ରିଭିଜନ ପେଣ୍ଡିଂ ଅଛି ସେ ମୋର ଚ୍ୟାଲେଞ୍ଜ
Adjournment request. Yes, next.
Item 6.
CD has come.
My lordship.
Yes. Yes. Why? Let us see the prayer. You do have a case on merit or not? Let us. What is he asking for?
My lord, he is questioning for the FIR, my lord.
Yes.
And the alleged offence is 294, 506, 534 IPC, my lord.
Is there any interim order
No,
operating?
my lord, there is no entry.
Adjourned to March. Yes. Next.
Seven,
Same, my lord, same petition.
Adjourned to March.
item
On
nine.
request, huh? On request, correct. Fine.
CD is there in both cases.
Hmm?
CD is there in both cases.
Yes.
Item 9, may I please, Lordship?
All this, then comes for district submits that, person to do hear order. He has received the CD and the matter is ready for hearing. However, the then count for the petitioner seeks an adjournment in this matter. Hence, in the interest of justice, matter is going to March. Yes.
9, may I please, Lordship?
Yes.
Lordship, I'm challenging the cognizance order dated 18/12/23.
Sorry.
where I'm challenging the cognizance order dated 18/12/23
Yes.
took against the petitioner in Baleswar vigilance case number such and such, where petitioner has been implicated under sections 7, 7A and 12 of the PC Act.
Hmm.
My lord, petitioner was the in charge of that Baleswar town police station, and petitioner has not taken any illegal gratification from the informant, but the co-accused person, some colleagues, SI and constable, who took the bribe and by telling that the madam will also get share from that. My lord, petitioner has never.
That's what is happening in police, all police stations.
And my lord, the petitioner has never
Everybody is
contacted.
not collecting money. One of the police officer will collect and it will be, the booty is served between all of
My lord,
you.
petitioner never contacted with the informant. He never met.
Madam,
never
in
get-
the cognizance stage, do I need to go into all these things? You tell me.
Lord, matter is ready for charge. I'll move.
You argue that.
Well,
Petition earlier before petition number twice. That has been disposed. Once.
Let her go and argue whatever you want.
Given certificate, sir.
Petitioner is agreed by the order dated. Where is the order dated?
18/12/23.
18?
12/23.
18/12/2023, passed by the Special Judge Vigilance Baleshwar in Vigilance PS case number 19 of 2020, whereby the court below has taken cognizance of offences punishable under section 7 /7 capital A and /12 of PC Amendment Act 2018. The petitioner has vehemently argued that no case is made out against her client, even if the prosecution case as such, a prosecution case at its face value is accepted, and she has taken me to the contents of the charge sheet and the documents form part of the same. I am not inclined to entertain this petition at the stage of however liberty is granted to the petitioner to raise all the point that the appropriate says in the piece of the time. Yes, with this observation, petition is disposed of. Yes, next.
Item 10.
Full money.
Yes.
Passing of the order of cognizance, the necessary exercise change of 7 other references was justification filed in 498, 298, 322, 506, ready for
Yes.
reply.
Yes.
307 has been deleted here also. But other offences are clearly made out from their pressure of the
Where is it? Where is the charge sheet?
Justification not in this case are not
Nothing.
only FIR and the other cognizance also, that is place 13.
I'll just pass it over. We'll
Yes,
see.
sir.
Otherwise, dismiss. Yes, next.
Number 11.
My lord,
Yes.
here last time I had added the state to got the CD because it is my specific case that although my lord, as per the FIR, it is alleged, my lord, may see the offences are 379 and 34 IPC of that theft of laterite, cutting at removing of the laterite stone, and did not come into the lordship. CD is not come.
Have I asked for CD?
My lord has said directed me to file charge sheet as well as directed him to get the
Charge
CD.
sheet has been filed?
Yes, I have given a copy, my lord.
Yes,
You
there
have
is no instruction in lordship, but the last order in 26/11/2024, there is no reflected regarding call for the CD also.
Call for the CD.
Yes.
Call for the CD. Right. Call for the CD, release the matter. Yes.
12.
First week of January.
Yes.
Your lordship. Well, item 12, The matter is arising out of complaint case, my lord. In the meantime, the matter is compromised, my lord. Relevant case, my lord, 34 under Annexure 3. That is a
Annexure 3.
joint affidavit, my lord.
Annexure 3, joint affidavit.
My lord.
Where are they?
My lord, the deponent number 1 is the complainant in the Lorraine trial court below.
I know, but where are they are here?
No,
today.
my lord, right now, no.
Why?
Well,
Call them.
Notice has been not issued.
Notice is not required. You have to settle the dispute. Bring her. Bring him.
My lord, any sort date maybe.
Session other arrangements.
Arising out of a complaint case.
Yes, sir.
Yes, ma'am.
Hmm. You bring him tomorrow?
My lord, my lord.
Tomorrow?
Yes, ma'am.
Tomorrow. Bring them. It is complaint. What are the offenses? Is there any serious offense? Legal impediment is there?
323, 294, 42506, and rated 31 R S of the S and 2 B of the civil.
It's all right. 307 is taken out.
My lord.
It's a 200 CRPC petition. Okay. Bring them tomorrow. Tomorrow.
Yes, ma'am.
Yes.
Obligation.
Yes.
May I please also? But this application, it's a maintenance case, my lord, challenge the interim maintenance ordered by the learned family court.
Yes.
On the ground, my lord, section 125 subsection 4 is applicable to this case, where it has been stated that if the wife stayed on her own will and wish separately without giving any,
If the principle is the wife has withdrawn from the company of the husband voluntarily, then she is not entitled to relief under section 125. This is the principle.
Exactly.
You show me that.
Yes, that I'm saying.
Yes.
You'll also may kindly see.
Show me that voluntarily she has withdrawn or she has deserted you.
Yes, yes.
Either of this.
You'll also may annexure 2. You'll also may kindly see.
Yes.
Annexure 2, page 22.
Yes.
But she on or after, just after the marriage was registered, just after the marriage.
What is this? Faisala Nama.
Yes. He made an
Picture of
agreement.
Faisala
Yes,
Nama.
made agreement. I do not want to stay with you. I want to stay separately, and you get separated from me. That is his version, and accordingly her own will and wish.
No, this is a joint.
one.
No, this is a joint version.
This is one.
This is a
Then
settlement.
next you'll also.
Yes.
This is one. This agreement is first. Then you'll also make kindly turn to page. The affidavit,
Yes.
as per his own will and wish, I have filed an application under section 13B of Hindu Marriage Act. You also may kindly get it on Annexure 4, page 31.
Yes.
You also got it?
4.
Annexure 4, page
Yes.
31.
Yes.
This is my lord, the order as per her own will and wish. I have filed this 13B of Hindu Marriage Act, where she has filed the affidavit. You also may kindly see Annexure 5.
5.
Annexure 5, page 35.
Where is that?
You also may kindly see.
Read it.
Let's you got it.
I am not interested.
I am the opposite party in the above mentioned matter, that I have gone through the facts stated in the petition filed by the petitioner. Petitioner means my lord, the present petitioner. That I am not interested to contest the case due to my social status and prestige, and also
Contesting is
my lord,
Yes.
just I have no objection if the prayer made by the petitioner.
that's right. But is it you are drawing inference out of it? Where she has said that I am not interested to stay with you.
No,
She may say that I am not interested to contest this petition
no.
out of her station.
I am not on that part, my lord. I am first the agreement.
Agreement is a joint agreement
Joint
between
agreement.
you and your husband.
Yes,
She says that I am not interested.
not interested to stay with you.
Unilateral statement of
Yes.
the wife that
Yes.
I am not interested to stay with you.
Stay with you.
Show me unilateral.
That is the agreement, and that this is the affidavit. She has herself shown.
This
the
affidavit, she only says that I am not interested to contest the case.
Yes.
Doesn't mean that you can read in between the lines.
My lord, since then, since from the date of filing this affidavit, as per her own will and wish, she was separately staying, and after 10 years, 125 petition has been filed. After 10 years,
What happened at the marriage front?
nothing, my lord. Neither she has given any affair against me.
No,
That
what
I have
happened?
tortured.
What happened to this proceeding?
Proceeding?
Which you have initiated.
That,
civil proceeding.
yes, yes, that page, annex 4, page 31.
What happened there?
This is the honorable court has observed that since the time limit is not completed, so I am not inclined to allow this divorce proceeding. Kana ବର୍ଷେ ହେଇନଥିଲା, 1 year ହେଇନଥିଲା. That is why the court inclined. But
Now,
accepted.
why didn't you repeat the petition?
But she separately stated. She
Because-
separately did not.
Because see, 30 for the proposal for
Yes.
13,
Yes.
1 year is mandatory. Otherwise, before marriage within 1 year,
Yes, yes.
then section 12,
To
penalty
section
of
12.
marriage.
Yes,
Specific grounds are there.
yes,
After 1 year only you can revoke, invoke 13.
exactly.
So rightly rejected.
She rightly rejected.
You slept over your right.
No, I did not sleep. She did not cooperate with me.
Then why have you not filed any proceeding?
So, I have filed.
What?
I have filed divorce proceeding.
Where is that?
Yes, my lord.
Where is that? Where is that proceeding?
I am giving.
What is happening to that proceeding?
Yes.
What is the, by the way, what is the amount awarded
Till 5,000 per month
from the date of
from the
application?
date of application. From the date of application.
What are you doing for living?
I am a private driver, my lord, daily wages. I don't have any income. And she is an advocate. She is an advocate. And after 10 years, you also may kindly consider the conduct of the.
Okay, I'll issue notice.
Yes, yes.
10 years, he moved the application. Let us.
Yes, yes.
Okay.
After 10 years, why is he
Issue-
slept
issue
over the
notice to
matter?
Opposite party number 2, returnable within also. The proceeding before the court below. Where is that application?
But yes,
Stay of proceeding, what is that proceeding? Proceeding, the execution proceeding, number 27, execution case number 27.
27 by 2020.
2024, pending before SDGM Banki, is the state till next date of
Right.
subject to the petitioner continuously paying the monthly maintenance.
You'll also may kindly say, I can say.
Areas I can examine, but you can pay.
No, no, you'll also may kindly direct me to pay the area.
No, I'm not saying area I'll see.
Huh.
Only continuously pay 5,000 rupees every month.
Both problem.
It's a matter of after January, I'll hear it. 1 month pay only 5,000. Yes.
Yes, yes.
Put it in
Yes,
January.
yes.
Stay subject to petitioner paying the monthly maintenance. Release the matter. Yes.
Yes.
January 2nd week. Yes.
Item 40.
Item 45, please, my lords.
Yes.
There is no CRLMC.
Yes.
My lord, I'm praying for an adjournment in both the matters because, my lord, on the last.
You'll also directed to pay the amount specifically mentioned, that is 4,000, not 5,000.
4,000.
Yes.
Subject to paying monthly maintenance.
Monthly.
Yes, directed. Yes.
My
Yes.
lord, on last occasion, your lordship's viewers, after divorce, it will be cost, my lord, amicable settlement matter, my lord. So, my lord, I pray let the matter be listed on 2nd week of January so
Why?
that, my lord, divorce is ongoing, my lord, and I'll submit that certified copy, then, my lord.
Lordship, by directive 4/11/2024, this honorable court directed to bring judgment part.
That is what I'm saying.
8 of the Special Marriage Act, Lordship. Page paragraph 7 of the Lordship.
Yes, I know.
Yes,
That is what I'm saying.
He is aiming at something else. In January.
January
Well,
2nd.
he knows that I may not keep.
No, my lord, no, my lord.
Please-
The judgment is awaited, my
Okay,
lord.
it's all right. List it. I understand it. List it in January. Okay.
My lord, in the first matter, my learned senior is appearing and
Both the matters. Both the matters. Yes. 14.
I'm grateful.
Item 50.
Mr. Bhai has gone to his village man. Fine.
What is this matter? Just see. What is this?
Arising out of a complaint case.
Hmm.
The complainant has filed 1cc against the opposite party, stating that he has forged some document and he was appointed as a lecturer first post in Owl College. That while he continuing as Owl College, simultaneously he is working in Sarva Shiksha Abhijana in a school.
You don't have any case. Rightly cognizance is taken.
And the complainant is stating that the other offences should be added. He has filed the protest petition against the charge sheet and
He has a remedy before the court.
Yes, ma'am.
You can move application there. Can't. Petitioner is the complainant, huh? Petitioner is the complainant.
Complaint.
Petitioner is the complainant
And,
in FI in
Sub item is
one
the-
ICC case number 14 of 2024, whereas the opposite party number 2 is the accused. A petitioner is agreed by the order dated. Where is that order?
That is page 11.
Date you tell me. Order dated 24/6/2024 passed by JMFC all in 1 CC case number 14 of 2024, whereby cognizance of offences punishable under section 468 CRPC has been taken. The petitioner being the complainant is agreed for the fact that the trial court has left out the offences punishable under section 193, only 420, only 406, only 403, only 409 IPC, and no cognizance has been taken despite offences are made out. Offences are made out. Offences are made out. I am not inclined to entertain this petition at this stage, as appropriate remedies are available to him, available to the petitioner before the court below, with the liberty to raise all the points before the court below. The present petition is disposed of. Yes, next.
Next sub item,
Hmm.
the opposite party here is the petitioner challenging that cognizance.
In view of the order passed by this court today in CRLMC 3675 of 2024, no order is required to pass in the present petition. Equally, the present petitioner has the liberty to raise all the points before the court below at the appropriate stage. With this liberty, this petition as well is disposed of. Yes, next.
16.
My appeal also. Sir, I have challenged the order of cognizance. In the meantime, already charge sheet was a file.
Charge sheet
already
and CD should call for.
Why, Mr. Patil, do like this?
Limited grievance.
And you know when I will impose cost again.
Petitioner was not on bail. That's it. I've
See, you are challenging cognizance order. You don't file the charge sheet.
Khali bail by prayer courts. Lordship, first and second up.
What do you want?
I want to surrender before the court below.
Surrender, who stopped you?
All the co-equals release on a bail. That's it.
Give me. All shortcut 482 petitions, sir.
Limited grass.
A communal riot in Sambalpur, the Hanuman Jayanti. That communal riot.
Let them take it. I know. Although the petitioner had challenged the order dated 26/7/2023 passed by Legendary Region Sambalpur in DR case number 947 of 2023, whereby cognizance of offences punishable under section attorney general, page 11, so it has been taken against the petitioner and many other co-accused persons. How many accused
37.
36. Other 36 co-accused persons. But Mr. Patel at the outset submits that he won't be pressing this petition, rather reserve his right to raise all the points before the court below. At this stage, Mr. Patel further submits that how many accused persons have been granted bail?
Almost all.
Almost all the accused persons have been admitted to bail, either by this court or by the trial court by various orders. He has also hands up the order dated 9/7/2023 passed by this court in BLAPL number 6789 and 6849 of 2023. Apart from that, he has also hands up the order passed by the additional sessions judge Sambalpur on 27/9/2024. Perusal of the judgment reveals that the co-accused persons have been granted bail on various conditions. He submits that the petitioner may be granted liberty to appear public surrender before the court on before 30th of December,
Yes, sir.
30th of December, and resort to the remedy available to him under law. The petitioner may surrender, subject to the petitioner surrendering the petitioner may surrender before the surrender of with the appeal of and move appropriate application for grant of bail on all the grounds agreed in the present petition, including the ground of parity. If such application is moved, the same shall be considered on the same. Yes. With this observation, the petition is disposed of. Yes.
17.
Yes.
Lordship, I am for the petitioner.
Yes,
Lordship, the petitioner is challenging the order of Cognizance order dated 31st July 2023. The fact of the matter is, Lordship, his elder brother, he has taken money from the informant.
Yes.
All the money has been transfer account wise.
To your elder brother.
Elder brother.
Yes.
And it has been reflected in the FIR and in the 161 statement. Everyone has said the elder brother has taken the money through account. Petitioner is no way contacted the informant. Petitioner has never claimed the money. Neither the informant has given any money to the petitioner.
And charge sheet has been filed.
Charge sheet has been filed.
Let us
Lordship.
see what are the allegations against you. And you are against the cognizance order.
Lordship.
Yes. Let us see why cognizance is taken against you, despite nothing is there. Let us see. Yes.
Lordship, may I read the statement of the complainant, 161? Lordship, ମୁଁ ଜ୍ୟୋତିଷ ସାହୁ ଆଜି 11/10/2022 ରଖି ଆପଣଙ୍କ ନିକଟରେ ମୋର ଦେବା ବୟାନ ଏହିକି ଯେ ମୁଁ ଛତିଶଗଡ଼ ଲୁହା PSC ରେ ଡାକ୍ତର ହିସାବରେ କାମ କରେ। ମୁଁ ଜାନୁଆରୀ ମାସରେ 2020 ମସିହାରେ ଘରକୁ ଭୁବନେଶ୍ୱର ଆସିଥିଲି। ସେହି ଆସିବା ସମୟରେ ମୋର ଜଣ ସାଙ୍ଗ ତୁଷାର କାନ୍ତି ମହାପାତ୍ର ସହିତ ମୋର ଦେଖା ହୋଇଥିଲା।
ତୁଷାର କାନ୍ତି ମହାପାତ୍ର?
ତୁଷାର କାନ୍ତି is a friend of the informant.
Yes.
ତୁଷାର କାନ୍ତି ମହାପାତ୍ର ସହିତ ଦେଖା ହୋଇଥିଲା ସମୟରେ ତାଙ୍କ ସହିତ ବିଶ୍ୱଜିତ ମଳ is the elder brother of the this present petitioner, ଯାହାଙ୍କ ଘରେ କାକଟପୁର ପୁରୀଙ୍କ ସହିତ ମଧ୍ୟ ମୋର ପରିଚୟ ହୋଇଥିଲା। ତାପରେ କିଛି ଦିନ କଥା ହେବା ପରେ ବିଶ୍ୱଜିତ ମଳ ମତେ କହିଲେ କି ବାପି ମଳ, but I am happy ମଳ। Present petitioner is happy। ଦେବାକୁ ପଡିବ। ଏବେ ମୋ ଭାଇ ହାପି ମଳ କଣ୍ଟ୍ରାକ୍ଟର କାମ କରୁଛି, ମୋର ଦରକାର ଅଛି। ମାନେ he has demanded some money from the informant
for you.
For him. That is his statement for me.
No. Your brother has asked the money to be utilized by you.
Yeah.
You are happy.
I am happy.
Yes.
ଅଛି। ମତେ ଚାକରି କରେଇଦେବା କହିକି ଠକିକି ପଇସା ବିଶ୍ୱଜିତ ମଳ ନେଇଛନ୍ତି। ମୋ ଘରେ ମୋର ବାପା ଏକଟିଆ ରହିଥିବାରୁ ମୁଁ ମଧ୍ୟ ତା କଥାରେ ବିଶ୍ୱାସ କଲି। ମାନେ she has relied on the elder brother. That elder brother promised her to provide a job at Orissa. So that's the reason the elder brother demanded 20 lakhs.
Yes. What do you say?
But
there is no allegation against him.
But due to necessity of the present petition,
maybe necessity.
Request
for my necessity, if somebody is asking and taking money,
but
how am I responsible?
That's right, Your Lordship. I am not disputing.
Then
here is the 420 compoundable, but whether the present petition brother ready and willing to refund that alleged amount to the present.
The brother might have taken money. Who knows? What has he done?
Not directly transfer.
And it's read your charge sheet. In the charge sheet also the same.
The brother account to ସବୁ ଟଙ୍କା transfer ହେଇଛି Lordship. For the utilize the.
What is the amount, by the way?
7,70,000. And the elder.
It seems you are richer than your brother. You pay.
I don't know the.
You are the contractor.
I am the contractor. My brother is taking in my name. How can I?
I'll issue notice and stay. There is nothing. Why don't you settle? What is the amount?
I am not interested. I don't know I don't know the informant. I am not in contact with her. My elder
What
brother
is the amount you tell me?
7,70,000 and 1 lakh the elder brother has paid.
Paid.
That what she has
The
stated.
problem is you have not implemented the informant.
Not sure.
You should have implemented the informant.
Not sure.
Implement the informant, at least I can send it to the mediation and finish it up. That's a good idea. I'll stay the proceeding. Implement. Okay. Right on. The learned counsel for the petitioner seeks permission to leave or to implement the informant is opposite party number 2. On implement for the opposite party number 2, issue notice to opposite party number 2, written state. And the counsel for the petitioner submits that absolutely there is no allegation made against him. It is alleged against it is alleged by the opposite party that the brother of the present petitioner had taken about 7 lakh rupees.
7,70,000
rupees on the promise, 7 lakh promise, stating, inter alia stating that the same money would be paid to the present petitioner,
And elder brother-
who is a contractor. I have perused the charge sheet and the statement of the witnesses recorded under 161 CRC. Indeed, there is absolutely no allegation against the present petitioner. Present petitioner. In view of the aforementioned, what is the where is the proceeding pending?
The GMC Bhubaneswar.
In view of the aforementioned, the proceeding pending before
GMFC court.
GMFC, so arising out of so is state qua the present petitioner, Next over. Regarding had to the fact that the dispute is regarding payment of about 7 lakh rupees, and there is Mr. Counsel for the petitioner submits that his brother has made good certain amount of to the opposite party. I feel it appropriate to where is the FIR? Which police station?
So
Page
11.
11.
Bhubaneswar.
Bhubaneswar.
Appropriate to relegate the petitioner and opposite party and all other stakeholders in the present case for exploring a possibility of settlement before the mediation center, Bhubaneswar. The state mediation center, Bhubaneswar, is directed to coordinator for this mediation center. Bhubaneswar is directed to fix a particular date and intimate the same to the to all the stakeholders. And after exploring a possibility of settlement, file a report before this court. Leave the matter. Awaiting the mediation report. Yes. Pay the money and finish it up.
Elder brother has to pay. I am not concerned.
After I quash it, then your brother will be concerned. Then he will come and say that my brother's case is
I want to come
quashed
for
yes.
obliged.
Yes.
May I please, Your Worship. The petitioner prayer for quashing the FIR and the entire proceeding, my lord.
Yes.
The petition on the basis of the FIR lodged by the OP number 2, my lord. The case under section 296, 122, 285, 35, 109 of BN registered, my lord. The petition is the husband, opposite number 2 is the wife, my lord. The petition was arrested and forwarded to London magistrate. Prayer for bail having rejected after to London session judge for bail, and the prayer for bail is allowed. He is a religion of bail. At the time of hearing the bail application, the OP number 2 had filed an affidavit. I invite your lordship attention to page 18, my lord. The affidavit filed by the OP number 2, my lord. Para 1, my lord.
Yes.
May I read, my lord?
Yes.
That I am the wife of the accused petitioner, Mr. Sankar Mishra, and
The
would
relevant
like-
para 4 is the relevant.
Yes.
and I-
Yes. Tell me.
I am the wife of accused petitioner, Mr. Sankar Mishra, and I would like to state that I have made the FIR against my husband because of some misunderstanding and anger. And all the statement that I have given against him is due to misunderstanding. And I, being the informant of the case, don't want to proceed further in this case against him. We want to live a happy family. That the fact is, that the fact is,
Issue notice to opposite party number 2 written so. And what is the case?
the charge sheet is not been submitted.
Okay. issue notice. General, yes.
19.
My lord, I don't pass over, my lord. Mr. Das.
20.
And in this case, my lord, when petitioner prefer allow the 311 petition which is rejected by the Lawrence JMFC,
Show me the 311 petition.
my lord. And in this
Like copy of the petition may be served on us.
already served, state copy already served.
Yes. The 1cc case.
1cc.
Yes. Yes.
The petitioner, there is annex 30. The petition to recall the PW1 for the cross-examination filed on behalf of the accused. That in the case accused exhibited the pocket note book consisting there is the detailed payment made to the complainant which marked with the objection during defense evidence. That the advocate for the complainant cross-examination, the accused at length disputed the payment given by the accused to the complainant. That at this juncture, it is highly necessary to cross-examine the complainant to respect to the payment made by the complainant through appropriate notebooks. That for the adjudication and to the meet end of the justice.
Show me your application under section 311. You have not filed anything. What is this case is about?
My lord, what happened, my lord? The present petitioner issued a check to the opposite party on 2013, and bank officer also admitted that se check taku tempering hichi. Your lordship kindly peruse the date be tempering, all the things also tempering. But in the present petitioner's notebook re achi je on that is issued on 2013. So in 311 petition we want to recall the PW1 for the examination of these documents or nothing else.
Which document?
Pocket notebook.
Why have you not done when he was in the dock? You should have done it. Why have you not done it? Where have you explained that?
Lawrence JMFC not listening anything, rejected our 311 petition.
That's the common grievance of all the lawyer against the judges. That's the common law. You show me your application. Where have you said that?
In our affidavit also all the things I have submitted.
Where is that?
In my affidavit.
Page.
Page 20.
20.
20. Paragraph 2. The advocate complainant cross-examine the accused. Length dispute the payment given the accused complainant. The juncture of the high necessary cross-examination complainant respect the payment made. Complainant through the appropriate notebook. What is
the check amount?
Check amount is 5 lakhs. My lord, what happened? Bank officer also admitted just said tempering hitch. All the things. Kintu said is khali guta examine hobo, so that what is right that will come to the
you pay cost. Huh?
My lord.
I give right now. Petitioner is an accused in 1cc case number 377 of 2018 for alleged commission of offences punishable under section 138 NIS. PW1 is the complaint. The PW1, the complainant, was examined by the court below, and the petitioner was afforded opportunity to cross-examine at length. After having cross-examined at length, the petitioner was not satisfied and moved an application. When did you move the application?
My lord, as per your lordship, on the 30
Moved application under 24
There is no other choice.
2024 under section 311 CRPC for seeking recall of PW1, that is the complainant opposite party in the present case. The said application has been rejected by the impugn order dated 30th September 2024 in Australia, stating as under first paragraph page 19. Mr. Das and counsel for the petitioner submits that the vital question which has been left, which could not be put to the said witness, needs to be put to him for just decision for the case. However, in the application for 311 CRPC, no proposed questions have been enumerated. Be that as it may, since the petitioner is an accused facing a criminal case for alleged offences under 130 he has indefensible right to defend himself, defend himself. Therefore, his prayer for recalling the complaint sounds reasonable. Therefore, therefore, the petitioner deserves one opportunity for cross-examining the complainant, being PW1. Accordingly, the impugn order is set aside. The trial court is directed to afford one opportunity to the petitioner for cross-examining the PW1, the complainant. The trial court is at liberty to examine the proposed question. The petitioner is petitioner shall in advance furnish the proposed questions to be put to the witness, and the same shall be the relevancy of the same shall be examined by the court below, and fix a particular date for summoning the said witness and put to the said witness to cross-examination. Accordingly, the present petition is allowed, subject to the petitioner paying a cost of rupees 20,000 to the complainant. I have done less because since you are appearing, it should be 50,000. 20,000 cost to the complainant on the day to be paid by the petitioner on the day of the cross-examination. It is made clear that the petitioner shall not seek any adjournment on any pretext whatsoever. Yes. Allowed. 15 yes.
Oblige.
21.
Please. Now, here, my lord, the petitioner has challenged the initiation of criminal proceedings and subsequent taking of cognizance by the learned court below on majorly on two grounds. The order of cognizance, the learned court below has not cited any reasons, and secondly, it was a transaction which was the OP number 2, the informant, my lord. Here, it registered a complaint alleging that 13 number of industries who have taken loan from OP number 2, they subsequently defaulted to make that payment, and it was alleged that some of those industries have not produced genuine documents.
Who are you?
I was one of the beneficiaries.
Yes.
I was granted loan by the Odisha Khadi and Village Industries Board. That was the OP number 2, my lord. Now, subsequent that was in the year 2003. Now, in the year and subsequently, when I defaulted the loan amount, my lord, the government initiated certificate proceeding against me, my lord, and that amount became 29 lakhs as of now, and I have already repaid that 29 lakhs. Which was 6 lakhs in loan amount.
But the document, the false document which you have given for obtaining the loan, that offense where
that was the allegation, my lord.
That's right.
That was the allegation.
Has to be ascertained.
But my lord, I have just cited. I'll just cite one judgment. It is very recent Supreme Court judgment, my lord.
Yes.
My lord. Yes, my lord. Yes. My lordship will see para.
Yes.
My lord, para 3.7, my lord.
3.7.
3.7.
Yes.
Since the proceedings for the DAT, my lord, settlement. Yes, my lord, since the proceeding for the DAT were still pending, the borrower's mortgagors approached the respondent number 2 bank for settlement of the amount due regarding the group loan accounts. To that effect, one-time settlement dated 19th number 15 of rupees 3.8 crores was offered to the respondent number 2 bank, settling all the dues. The same was accepted by
this is a case where the OTS was allowed, and on the basis of OTS, payment is made.
Here also, my lord, they have also recovered 30 lakhs.
Recovery is something different, OTS something.
But that was credited to the account of Odisha Khadi Village Industries Board, my lord. Pursuant to this, and here also, my lord, the allegation of forgery was there.
Yes.
I'll also, my lord.
Where is that?
My lord.
Where have you implicated the bank?
Yes, my lord. No, my lord, board.
Issue notice to the board. Issue notice.
A stay of further.
Learned counsel for the petitioner submits that the petitioner had availed loan. इसमें देखो petitioner is seeking quashing of the entire criminal prosecution. No, this is cognizance order.
Yes.
Quashing of order dated 6/5/2010 passed by the learned HTJM Bhubaneswar NGR case number 1723 of 2023, whereby cognizance of offences punishable under section
406,
406,
409,
409,
468, 471, 120, page 30.
471, 120B, 418 and 34. IPC has been taken against him and 39 others.
There are many others.
39,
39, yes.
39 others.
Well, I'm only confined to the
Learned counsel for the petitioner submits that insofar as the allegation against the petitioner is that he has obtained loan from the opposite party number 2, loan of to the tune of 29 lakhs.
29 lakhs, my lord, 29 lakhs, 79,000 to 88,000. 88,725.
From the opposite party number 2. Opposite party number 2. And the said loan amount has already been paid back.
Yes.
Paid back.
Page 13.
Still, the trial court has not taken into consideration the said aspect and had went on to take the cognizance of offences.
No, I'm sorry.
Mr. Tej.
Cognizance order was taken into your.
Yes, I understand.
10.
The counsel for the state, Tej Pratap, submits that the petitioners have petitioner and other co-accused persons have obtained loan from the opposite party number 2 by utilizing the manipulated and false document. Mere fact that the amount, the loan amount has been paid back will not wash away the offences which has been committed by them. Mr. Learned counsel for the petitioner has relied upon the judgment of the Honorable Supreme Court reported in so and so and submit that the Supreme Court in the exactly the similar circumstances has given indulgence and quashed the entire proceeding on the ground that the loan amount, although the loan was obtained on the basis of false document, however, after the entire loan amount is paid back, no case is made out against the petitioner. Issue notice to the opposite party number 2, written loan so. In the meantime, the proceeding pending before the court of SDJM Bhubaneswar in GR case number 1723 of 2003, qua the present petitioner is stayed. Yes, sir.
22.
Lordship, this is against a rejection of an application under section 311 TRPC for recall of 2 witnesses. One is the overhearing witness and the other one is the TLO.
Yes.
This is a trap case, Lordship, wherein the allegation is that the petitioner, who is the RI, demanded bribe of rupees 5,000 for submission of a report.
Yes.
Lordship, may kindly come to the petition which is at running page 18. 18.
Yes.
May I place the petition?
Yes.
Para 2, Lordship.
When you seek recall of PW5
At the stage of argument, after the cross-examination of the IO, it was posted after around 3 to 4 days for
statement of
argument.
Statement of accused 313 statement recorded.
No, but it is that is over. That is over. The case is at the stage of argument, and my submission, my pleading in the petition, I have mentioned. Lordship,
what are you going to ask them?
That Lordship, may kindly see that while preparing for the argument of the case, it was detected that some important questions relating to the spot map exhibit P23, the position of the overhearing witness who claimed to have stood near the window of the RI office, the position of the complainant as well as the accused at the time when the complainant entered into the office of the RI office at the time of the trap have not been elicited in cross-examination.
The map is there. From the map you read it.
Map is there.
Things are there always.
Map is there, but it needs to be confronted to the witness as regarding the position of the window. the most important question is, Lordship, the MAP will nail the lie after it is confronted, because in the MAP, the position of
The map has already been exhibited
Lordship,
as the exhibit P23.
P23.
And wherever the position is shown, it's shown.
It is shown, but it needs to be brought, something more is to be brought from the overhearing witness,
Yes,
Lordship,
ma'am.
because that will nail the lie of the overhearing
But the
witness.
problem is at the stage of argument, when you are preparing for argument. all this-
Only one date and only one date and I will complete, Lordship.
That's generally, I generally.
I will complete.
Case 23 or 25.
23.
The case in hand has the effect relevant. The questionable aspects raised in the instant petition were also asked to the said witnesses during cross-examination. Therefore, long after closure of the case from the both sides, when the matter is pending for argument, this does not find any justification. This is already asked.
No, Lordship, I am today.
Where are those?
Today I am filing 4 and 5, Lordship. There.
This
It has not been asked.
when the
It is
trial
not.
court is saying.
Let us see.
Small cross examination.
What map must have been exhibited.
In the cross examination. PW5, it is not put.
9, Lordship, may kindly say. 9 is equally. So, this is a mistake actually committed, and this is a very important aspect. It's a very important aspect. One date I will finish it.
That's wrong noting. He has not put that question. Right. I will give one opportunity, no adjournment.
No adjournment.
And you have to pay little cost.
Lordship.
Yes, sir.
Lordship, I will pay the bata of the witnesses.
Right. Okay. Petitioner is an accused facing trial for in Jaipur Vigilance PS case number 12 of 2021 for alleged offences punishable under section so on so on. The prosecution evidence has already been concluded in the case, and the statement of the accused under section 330 also has been recorded. At the matter is
Posted for argument.
set for final disposal. At that stage, the petitioner discovered that vital questions regarding the relating to exhibit P23, the spot map, has been left out to be put to the two witnesses, namely PW 5 and 9. Therefore, on 30th October 2024, the present petitioner moved an application under section 311 CRPC seeking recall of the PW 5 and 9. PW 5 and 9.
And 9.
The learned trial court by the impugn order dated 8/11/2024 rejected the application moved by the present petitioner on various grounds, including the ground that the questions to be proposed to be put to the said witnesses, namely PW 5 and 9, has already been put to them in their cross-examination. Therefore, recalling them for posing the same question is a futile exercise. On that ground alone, the trial court has rejected the application. Mr. Moon, learned counsel for the petitioner, hands up for the surveyed copy of the deposition of PW 5 and PW 9. I have perused the statement, perused the deposition of both the witnesses. In the cross-examination, indeed, the petitioner has not specifically put any question regarding exhibit P23, the spot make. Since the petitioners are facing a trial of grievous offences under Prevention of Corruption Act, he has indefensible right to defend himself in the present case. In that view of the matter, I am inclined to entertain this application despite the vehement oppose made by Mr. Maharana, learned counsel for the vigilance. In the vigilance for the on the aforementioned reason, the application present petition is allowed. The Special Judge Vigilance Bhavani Patna is directed to fix a particular date and summon both the witnesses, namely PW 5 and 9, and afford a singular opportunity to the present petitioner to cross-examine these witnesses. And the petitioner is also directed to furnish in advance the proposed questions to be put to the
Questions ta karantu nahi lordship. Questions will clothe them with the answers, and my purpose will be frustrated. Because an independent, had it been a
recall them
legal witness, it would have
no advance to the judge, not to the
judge,
to
without
the court,
serving
to
any
the court.
To the court.
Let the court.
Frustrated.
Advance question.
The petition is also directed to furnish in advance the proposed questions to be put to the
court, who in turn would examine the relevancy of the same. It is made clear that the petitioner shall not take any adjournment on the date to be fixed by the trial court for slotting for cross-examination of further cross-examination of said witnesses. Subject to the how much cost? Who are these two witnesses?
One is a independent official witness who is locally is available. So the cost will be within 500 for that witness.
No, that is that money. That's
and the other one is the IO who is
both of them are government
Nabarangpur.
And they pay to the bar.
Bar
pay to let them pay to the
bar को कर देना
10,000 bar. Payment of 10,000 rupees to the bar.
10,000 होती का?
No.
Comedian 5,000.
Corruption case 10,000 is nothing, and that is
RI.
It's all right. RIs are more powerful, you know. After all, you are giving to
5,000.
Yes, bar. You pay. Yes.
23.
Yes.
Yes.
Recipe. What are these two applications?
So the two applications, here the applicant is challenging the order by learned trial court, Vigilance, Sundargarh, where the appellant has been convicted under.
What is the sentence?
So sentence for 3 years and fine amount of 1 lakh rupees, Your Lordship.
1 lakh rupees?
Yes, Your Lordship.
Do you have a case on merit?
Yes, Your Lordship. So, Your Lordship, sir, I would like to submit 2-3 points, Your Lordship. That is very important. During his kindly have notes, Your Lordship, the date of occurrence, according to the material submission, it's 1976 to 1996. So during that 19 years of observation period, the FIR has been lodged against the appellant, against the appellant, and yes, DA amount has been it's 3,40,669.39, Your Lordship. That has been observed during the check period, Your Lordship. And the percentage, according to the judgment, is 59.63, Your Lordship. That is to say 60%, Your Lordship. So now, Your Lordship, there are certain things that has not been observed by the IO, neither by the learned trial court, Your Lordship. That is, Your Lordship, I would like to place 3 points, Your Lordship. First of all,
you have a good case on merit, I'll admit it.
Oblige, Your Lordship. Lordship, but there is a humble submission, Your Lordship.
There is every possibility of success, my lord.
Right, okay. Admit the appeal is admitted. I number 3141, the realization of the fine is stayed and suspend is sentence is suspended.
Your Lordship,
Yeah.
one more thing I would like to place that the interim bail has been granted by the learned trial.
I'm granting bail.
No,
I'm granting-
no,
Yeah.
that is for the period of 1 month, Your Lordship.
It's all right, I'm making it up.
That has not been filed, Your Lordship. Please kindly allow.
It's all right.
it as soon as
I-
it will be possible.
Bail granted, bail granted.
Suspension of the order.
Mr. Usual opposition. Vice Mr. Sanjay Das. Give a copy to.
Yeah, yes, Your Lordship.
Call for trial court record.
DCR, it may be listed after receipt of this DCR.
Lease the matter for final disposal after
Jyoti.
receiving a vote.
After receipt of the TCR.
Your Lordship, urgent certified copy may
Urgent.
be issued, Your Lordship.
Okay.
Oblige.
Obliged.
Yes, 24.
Right, Your Lordship.
Yes.
My lord, in this case, the petitioner challenged the order dated 6/8/22, my lord. As the learned court, Special Judge Vigilance Barampur has directed to not to alienate the property of the petitioner.
What is that affidavit was directed to?
My lord, this is the affidavit, my lord.
See, the affidavit was directed long back, March 23.
Yes, my lord.
You have not filed.
Yes, this is the affidavit, my lord. I have already sought the copy.
You file it, madam.
One vigilance case is pending.
That's right, but this big thing you have to file it. File it. Table is, huh? Pursuant to the order dated 21/3/2023, the petitioner has not filed the affidavit as yet. However, during the course of hearing, learned counsel for the petitioner has hands up for the affidavit. She may file the affidavit before in the registry. File it.
Can you fix a date, my lord?
A date will be fixed, madam. You should have filed. I would have heard it. Yes. File it in the registry because see, lot of papers are not legible. If you scan it, nothing will be legible. Just see your papers.
Old papers are there, my lord.
So you type it out. You have to type it out. Otherwise, once you scan it, nothing will be visible. Just check your third and fourth annexes. Yes.
Obliged.
Get it. Yes.
Will you kindly pass over?
Pass over. Yes.
26.
Next, Your Lordship, Belgium matter, my lord. NMW dated 26/24, 48/2024 and
bail
granted antecedent bail 6/3/20.
You 500. Yes.
Obliged.
27.
Pleasure, Lordship. This is a Belgium matter, my lord. NBW was issued by the order dated 5/11/2024 at page 11, my lord.
Bail.
Bail, my lord, by the order dated 4/11/2015.
NBW 5/11/24. 500.
Obliged.
Yes.
28.
Belgium matter, Lordship. Order dated 16/7/2024, Lordship.
NBW, huh?
Lordship.
And bail?
Bail, Lordship. 25/10/17, Lordship.
2007.
70.
70. Okay. 500. Yes.
29.
29 Belgium Mallet, NBW dated 24/7/24. And bail was granted on 20/12/24.
20.
2018. 2012/2018.
2020. Okay. 500. Yes.
30.
NBW was issued on 28/10/2024. It was granted bail on 20/12/2002.
Okay. 500. Yes.
31.
Belgium matter, NBW was issued on 1/10/2024 and he had been granted anticipatory bail on
9/2023.
14/9/23. Okay. Okay. 500.
32.
32, my lord. This is a Belgium matter, my lord. NBW dated 16/7/2024, my lord. And previous bail, my lord. Paragraph 4 in my petition, my lord. 13/4/2021.
13/4/2021.
By the ABL number of
3922. 500. Yes.
33.
My lord, bail application, my lord. Yes. Here, charge sheet submitted under section 376 2N 6 POCSO along with other offences, my lord.
Yes.
kindly
You
have a
have-
glance.
Yes.
Running page 33.
376, 2N.
Yes, my lord.
Yes.
Running page 33.
Custody.
Custody since my lord, 13/3/2024, and mean the charge sheet submitted on 2/5/24.
2/5/24,
my lord.
Okay.
My lord, kindly have a glance. Running page 33, the charge
33.
sheet, second paragraph, my lord. The second paragraph.
33.
Yes, my lord.
Okay.
Second paragraph. Made local, confidential inquiry.
1 minute. 33, sir. Yes.
Second paragraph, my lord.
Yes, sir.
Made local confidential inquiry.
So and so.
So and so,
It is
it
ascertained that
the
the victim so and so,
so and so,
they were so and so.
in the year
One daughter of her mother, so in the year
she was made
2024, complaint
admitted in plus 2 arts,
made
so and so college, Deepak Behra.
So police have
Last 3.
postponed since last 3 years, and this matter, the mother of victim show one has not to talk with Deepak Behra and has further insisted to stop conversation with him. And what are the offenses?
My lord, 376 2N.
What is the age of the
17 years, my lord.
Huh?
17 years.
He's in
They have
custody.
taken that girl my lord to their house. Thereafter they have assaulted my lord. There is injury assault injury there, but the fact
See, so 164, read 164.
164, my lord.
But this girl was in relationship.
Yes,
my lord.
He is also 21 years.
He is 21 years, 17 years.
This is what to do? Yes.
No.
Victim statement.
Victim statement 164 I am placing. ମୋ ମା ଏ ସମ୍ପର୍କରେ ରାଜି ନଥିଲେ।
I have perused the statement of the victim recorded under 164, 164 CRA, and related documents. From the evidence, it is apparent that the petitioner has been in relationship with the victim girl.
Yes.
Relationship with the victim girl. The mother of the victim was directly against the said alliance. Therefore, there was dispute. Therefore, there was dispute. Therefore, there was dispute. The victim in her 160 or 164 statement has also acknowledged this aspect that she was in relationship with the petitioner, and her mother was not agreeing with such continuation of such relationship with the present petitioner. Petitioner is a 21-year-old boy, and he is in custody since 13/3/2024. You don't have any criminal
No.
He is a first-time offender. The charge sheet has been filed now.
Yes, ma'am.
Charge sheet has been filed in the present case on
my lord 1/9/2024.
24. Cognizance, nothing.
No.
No cognizance, nothing. And the trial has not yet been commenced. Since the trial is likely to take considerable time, and the petitioner is already in custody for since 13/3/2024. Regard being head to the age of the petitioner and the nature of allegation, and I'm inclined to enlarge the petitioner on bail. Medical, you have filed some medical document.
Yes. Medical document is signed.
Medical record koichi.
Medical my lord,
There is absolutely no injury on the part of
injury achi body rocking of it is there.
not for the injury for the assault.
I have also perused the medical evidence. For the medical, the doctor has inter India described the following. The medical evidence reveals said under page 38 as per the victim statement. They had sexual intercourse 2 to 3 times with the consent of each other, and on October 23, this not the accused really entered into his house. Okay, I'll just come. Formal notice and Tuesday I'll pass the same order. ठीक है? और notice करके हाँ Wednesday रख दियो सेम ऑर्डर टाइप कर रखती हो नहीं इशू नोटिस एक जो ऑर्डर लिखी थी आई विल अलाउ इट बट वेडनेसडे सेम ऑर्डर ठीक है टेल हिम
No, I will definitely.
Definitely.
Because in his presence order was passed.
Yes, yes.
34.
No, you just tell him because see, the problem is he might have told his client by now.
No, no, more to
It will be unnecessary misunderstanding on his part.
I thought I noticed it.
ଆପଣ ବାହାରୁ କହିଦିଅନ୍ତୁ because it is an embarrassing situation for a lawyer, you know. He might have told his client that yes, you got the bail. thereafter पता चला कि नहीं है. This is very. We'll give it.
Again.
But I'll not upload this order till Wednesday. And Wednesday it will be listed. Then I'll upload this. But still, it's always better that you do.
34.
Yes.
34.
Henceforth, please be careful because I don't see whether notice.
No, my lord, I may be
made out to give it.
Yes. CDS I have not gone through the subsequent like order.
Okay. Adjana. Yes.
35.
35. 35.
Yes, 35, sir. You tell me.
35, my lord.
This is my second bail application. First application has been granted by the Hon'Ble court and directed to the lower court. And the lower court has not properly gone through the records. So that the rejection of bail.
No, I didn't follow what you're saying.
My lord.
I didn't follow you.
200 kg of ganja, my lord.
I took 35.
34?
35.
Yes.
35, my lord. CD টা আসে নাই 10টা ক্রিমিনাল আনট্রিটেড আছে
9
call for CD. Okay, we'll see. Yes.
36.
Here is also my lord 207 kg of 36 and 37.
36
and they are the outsiders. CD is not.
CD, call for CD. 36. Yeah.
38.
CD January.
Yes.
Yes.
But the 38 lordship will be seconds only. In the first occasion, lordship is directed to renew the prayer after examination. There is one sole eyewitness to the occurrence.
Where is that order?
Lordship.
Where is that order? After eyewitness is examined.
Only one eyewitness in the shady eyewitness.
Is the eyewitness.
Kumar.
Kumar Naha.
Kumar. So the only eyewitness to the occurrence.
But in the rejection order, it is stated that my lord and friend has stated that he is no more. But the fact remains, my lord, his some deposition has been, some witness have been examined, my lord. He has not supplied any.
He has not filed anything except rejection order. You file, bring that record, huh? Bring that. If the case is made out, I'll grant it. Yes.
39.
39, my lord, 376, 3 notice to go.
Notice to opposite party, victim, victim and informant. Yes.
Extra copy will be served.
Extra copy. Yes. 40
also, my lord, notice to both. 6 boxes.
Notice to victim.
My lord, application. My lord, this is the second bail application. First bail application was.
I am issuing notice to the victim and informant because these are POXO cases. Yes. Next. 41.
The petitioner has been charge sheeted for the offense under section 376 2 and 385 506
Yes.
420 of the Indian Penal Code.
Yes.
The petitioner was earlier approached the National Court in BLAPL number 6409 of 24, and your lordship has directed when the charge sheet has been submitted, you approach the.
Show me the charge sheet.
This is the charge sheet.
Notice has to go because 3.
No, madam. 376 POSCO is not there.
No, N is there. 3.
No.
376,
376,
2N. Yes.
2N.
Yes.
Victim is.
What are the allegations? Just you have not filed anything. What is the use of?
My lord, FIR I have filed.
Except FIR, nothing.
My lord, in the meantime, charge sheet has been submitted.
See me, that is why I relegated you to the trial court. After charge sheet is filed, you approach. Do you have the?
My lord, 164 statement is there. Serious allegation is there, man. Two persons have gone. Thereafter recorded the videography, blackmail, taken some money, my lord.
Read it. Mona,
Your lordship may kindly see the 67, 66 E of the IT Act was not there. Though that was the allegation.
Now that IT Act has gone. 376, 385, 506 and 320. Custody since?
Custody since my lord 23/4/2024.
Yes.
No, I am placing the one.
Yes. And 6 is a 6. 3 6. Ego 3 6. Part 1. And no. There is no miscarriage and all these things are also there. Allegations is otherwise. Right. The land counsel for the petitioner by emphasizing the medical evidence has submitted that the allegation against him that he is instrumental in aborting the pregnancy of the victim is completely found false from the medical evidence. Petitioner is in custody since 23/4/2024. 23/4/2024. Charge sheet has already been filed. The trial has not yet been commenced. And the same will take considerable time regarding it to the nature of allegation. It is you have to give it, huh? Well, sorry, regarding allegation about granted. Okay. And age of the petitioner is 25, huh? 25 years. Yes.
42 may have future loss.
But the 302 CD is not there.
CD, call for CD. Yes.
My lord, CD is available in BLA PL number 4151/2024, my lord.
Just check it up, huh?
Okay. Earlier bail application, my lord, however, directed in that bail.
Yes.
To individual.
43.
Your lordship, here is a case. Initially, no, yes. POSCO is there, your lordship. Notice will be issued to the victim.
Notice the victim informant.
Pardon, my lord. My lord, item number 42, short date.
Yes. Date will be there. Don't worry. Yes.
Only extra copy it will be solved. Extra copy will solve.
You please have.
Yes.
In all cases, my
Yes. Copy will be served. Notice copy served. Yes. 45.
Lordship, CD is there, lordship. CD is there.
Good.
Notice voter matter is chehegla from 30.
Google date sorted.
Yes, 44.
Yes, ma'am. The petitioner is arrested on dated 17/12/2023. And the custody is more than 11 months, near about 1 year, my lord.
Yes. Offense?
My lord, the offense
20B2IC and 29 by NDPS Act, your lordship.
Recovery.
134 kg, 700 gram, your lordship, for exclusive possession of the present petitioner, two brothers, your lordship, and owner and driver.
That is the, my lord.
Exclusive possession.
My lord, the earlier bail application also, my lord, is heard, and during that time, at that time, preliminary charge sheet has filed. That's why my lord is directed to the land court to renew the bail application.
Chemical examination report is filed.
That not in
Verify. Verify. Verify whether chemical examination report is filed out. Here. The petitioner to verify whether the chemical examination report has been filed along with the charge sheet or not.
My lord,
Is the matter.
next Friday, my lord. My lord, kindly listen next
He will
Friday.
read, he will give it.
Okay.
Yes, next.
45.
If your lordship 45 is the correct matter, corpuscle of matter, your lordship fixed it, but Tuesday, your lordship. Let it come along with your lordship.
Tuesday.
AFL number 10306 2020.
Okay, Tuesday, yes.
So all the matters will come in Tuesday, your lordship.
Yes, next.
46.
46 on this matter, I have prayed for only interim bail for 4 months because
I will cancer account se coach.
he's suffering from instruction new.
More.
You get in.
Documents.
Please supply the document.
The custody also, how can get document?
Verified, huh? Verified.
He's suffering from mouth.
No, interim bail application.
Interim bail, only
The
for
petitioner is seeking interim bail on the ground that the petitioner is suffering from
mouth cancer.
oral cancer.
It's oral cancer.
Oral cancer. The state council is to verify the same and release the matter next week.
Next Friday.
Yes.
47.
Second application, lordship. This petitioner is custodian 17th of April 2023. Lordship, the sections are 498A, 306, 304B and
Custody since?
custody since lordship 17th of April 2023.
April 23.
Yes.
In
It's a case of
304B.
It's a case
302.
304B.
Okay.
It's a case of completely suicidal. Also, I have given the postmortem report annexure to page 13.
Show me that. Yes.
Annexure to page 13, lordship, it's a case of suicidal hanging.
Yes.
Uh,
Yes.
And the normal dispute was there at the time of occurrence. The petitioner was not in the house, lordship. That is also
It was
stated.
a hanging case.
Hanging case, lordship.
Death is suicidal and lordship hanging.
Hmm.
Cause of death is asphyxia due to comparison leap and blink of air passage. That is the PM report. Your
PM report. I have annexed.
Hmm.
And present the husband in the outside lordship. So far present.
I am staying at Rajgampur. We are both were staying at Rajgampur, both husband and wife.
Show me that. What is the statement of the?
Lordship, the statement, lordship will can see statement of one Basanti Khatur and Sima Besan. Lordship, I am giving the passing over the certified copy.
Read it out.
Yes. It's a statement of Basanti Khatur. Is a resident of Thanrai Bhavan, Madhusudan Colony, PS Rajampur, District Sundargarh. मोर नाम बासंती खटूर बयस 50 उपलिखित ठिकाना मोर अटे आज 17/4/23 दिन मो सामने मोर बयान दिए मु मोर परिवार प्राय 2 वर्ष हेबो थंदरा भवन भड़ा रहउछु आम फ्लोर रे राजू यादव और तांको स्त्री सुमन कुमार प्राय 2 वर्ष हेबो थंदरा भवन भड़ा रे रहउचंती तांकर गोटे 9 मासर छोट पुओ अछि राजूर बापा माँ भाई माने तांकर घर बिहार रे रुहंती से माने एठा प्राय आसंतीनी राजूर 2 भाई भड़ा रे अन्य आडे रुहंती से माने मधो केतल केमते आसंती राजू ओसीएल रे चाकरी करे सुमन कुमार पुआ हला बेले सुमन भौणी संध्या कुमार यादव प्राय 3 मास बयस राजू पाखे थिला सुमन कुमार आम घरे आसी उठा बसा करती सुमन कुमार और स्वामी राजू यादव मझे मझे पार्टी पार्टी कर आसी कहला आस देखिबो सुमन कौन करिसे या शुणी मु आमर पड़ोसी जाई देखिलु जे सुमन तार चुनी रे फांसी लगाई फैन रे झुली पड़ी संगे संगे राजू तार बेकुरु चुनी को काटी दे तळको ओल्हाई देला और ताको साष्टांग करबा लागिलु किंतु किछि से किछि हलचल न होबा राजू एम्बुलेंस टाकी राज
constant case of the independent witness stated that there is a regular culture when present.
That is always there. If marriage is not happy, why anybody will go commit suicide? Forget about that. In the day of suicide, what had exactly happened? You tell me.
Due to hanging, the present person committed suicide due to hanging.
If it is happy marriage, nobody will hang.
That's right.
Why are you reading all these things? Marriage is always unhappy, therefore these things happen. On the day, whether what is his role, whether she has committed herself suicide or is a case of murder. 302 is ruled out.
No, 302
you have filed the charge sheet.
Yes.
So then the 306 will look.
304 be there. Then the marriage.
Then how many days you will keep him inside?
Yes,
you are in custody since
17
no. Petition is accused and so on so much. Allegation is also. After investigation, charge sheet has been filed on
Charge sheet from 13/18/2023.
13/8/2023 for LA's commission of offences punishable under section. The problem is you people don't file anything except FIR. You file nothing. Everything I have depend upon you. Whatever you say, I write it, and subsequently it is found that all are wrong. Because there is nothing paper. I have to depend upon you. Neither you give the charge sheet nor the statement.
Yes, that should have been.
What kind of petitions you people file, I just don't understand. And thereafter modification application, thereafter he says something, it's everything wrong. Give me the charge sheet copy at least. Earlier application was rejected.
Rejected, Lordship, in view of the development might have taken place because it was pending one and.
Where is that application?
That order has.
Where is that order? That also you have not filed.
Yes, yes.
You place it on record Tuesday, I'll see.
That is on record.
Tuesday,
I'll see.
It's very frustrating to see these kind
I'm
of
sorry, my lord, both are there.
everything. These are paperless court. Where will I keep these things? You tell me. If I pass an order without anything on record, tomorrow something happens. The complainant will come and make application.
I'm very sorry, Lordship. I have with the documents.
What will I do with these papers? Where will I keep these papers? If there is a file, I can put it there. There is no file. And you accept FIR, nothing is filed. You read out some evidence somewhere. I don't know whether it is related to this case or some other case. Whether he is a witness or not, I don't know. So please file these documents. At least it should come on record.
Yes, sir. She hands for her.
You file it at Tuesday, I'll take it up. I'll grant bail. You are entitled to bail, but at least you place this thing on record. File that. Earlier order also you have to file.
Yes, Lord.
Okay. Earlier order, what was the order? Have I said that if after charge sheet you file? What is the tell of the order?
Much has changed during this period. Therefore, on the press grounds, he would move to the court for grant of bail.
Oh, see, those things place on record.
Yes.
Tuesday. Yes.
48. My lord, petitioner is in custody since 13/11/23.
13/11/23.
13/11/23.
Okay.
My lord will kindly turn to Annexure 1, page 7.
What are the allegations?
My lord, 376(1), 294, 506. The date of incidence is 9/11/23. The FIR is registered on 13/11/23. 9/11/23 is the date of incident.
Yes. FIR?
13/11/23. My lord, the medical report is the charge sheet was submitted on 9/1/24 at page 24.
The brief is not with me, but copy not received.
Copy not receivable number habani.
PW1 come to the prosecution.
Yes.
Who is PW1?
24/9/1/24 at page 24 charge sheet was filed. I approached your lordship. Medical report is at page 36.
30?
There is 36, madam.
Okay. Come to 36.
Madam, there is no sign and symptom of
1 minute.
recent
1 minute. 36. Let me go. 36.
Six.
Okay. There is
There is no sign and symptom of recent sexual intercourse.
This is dated.
My lord, this is dated. My lord, 6/12/23.
Okay. Yes.
Then I approached your lordship at page 45.
45. Yes.
Your lordship held. Learned counsel for the petitioner hands up the copy of the charge sheet in court. Perusal of the statement recorded at certain sir, there is direct allegation against the petitioner. Victim initially in her statement has stated on 9/11/23 at 6 p.m. she had gone outside to attend the call of the nature. The present petitioner forcibly pulled her from the back and raped her. Learned counsel for the petitioner is relying upon the medical documents which were collected after 5 days of incident. It reveals there is no bodily injury sustained to the victim. Thereafter, he submits that apparently there is no resistance from the side of the prosecutrix, which leads to the only inference that it may be a case of consensual sex. I am not inclined to entertain this petition in this state.
Yes. Show me the prosecutorial evidence.
Yes. Prosecutor's statement is PW2, my lord, at page 48.
Yes. Yes. Yes, she has said the same thing.
Yes, but 9/11, 13/11 FIR, no recent sign of sexual intercourse. Examination after filing of the FIR. My lord, the medical report is absolutely silent. I am in custody since 13/11/20.
What is the age of this victim?
Victim is, my lord, 20.
Which
My
court
lord,
is
she is a
recorded?
married. Your lordship will see at page 49, cross-examination.
Yes.
I am illiterate. 8 years back,
am
prior to occurrence, I
illiterate
got
8 years
married to Tikun Behra of village such and such. 2 months after the marriage, my husband expired. After death of my husband, I am staying with my parents. She is a widow lady.
Yes. Come to the medical now.
Yes, medical is, my lord, page 48.
48.
Yes, I'm sorry, 36, man. Page 36.
36. Yes, show me.
My lord, serial number 3. There is no signs and symptom of recent sexual intercourse. Your lordship may see that.
There is no.
There is no bodily injuries on her person suggesting forcible sexual intercourse. At first,
Because these are paperless court. Yes, file it.
I will excuse my lord, I have told him.
Yes, there is a problem in the sense notice was not issued. Formal notice has to go. So same order I'll pass, but I'll pass it on Wednesday. Notice you file the requisite immediately. So that the technicality will be taken care of. Okay. Huh?
don't intimate.
Huh? He has in, but this technicality has to be overcome. Wednesday I'll take it up. Same order I'll repeat, but you file the requisite during the course of the day. Okay. You please file it. Okay.
50 pass over merit on behalf of Mr. Ray.
Yes.
51.
61.
May I please, madam?
Yes, madam.
76 to NU.
My lord, the earlier before your lordship petitioner in custody,
But
my lord.
TD hasn't come. That's what he says.
My lord, CD is available in earlier number, where petition for 1816/25. Petition is custody man 20 December 2023, my lord.
Yes.
And the earlier refer lordship and what your lordship disposed of the bail application, paragraph 5 of my bail petition, I have mentioned, my lord. Bill 1816/24, you also granted liberty after the exemption of the victim.
Yes, yes. Let them. I have issued.
Supplied the
Yes.
deposition copy
Yes,
and the
yes.
certified copy.
File it.
Short date, my lord.
Yes.
Bill.
Short date. Bail matters only short date will be given.
CD is available
Yes.
next Friday, my lord. Refer next
We'll
Friday.
give you a date. Yes.
52.
May I please listen? 12 of postcard is notice is required.
Okay. Issue notice. Huh? Notice to the victim as well as the informant. Yes.
53.
These are fresh bail matters or fresh bail matter again is listed. Oh, that was only for one day, no? Bail matter.
Where listing this on the person 40/50.
Yes.
53.
Present petitioner, languishing inside the case since 26/9/23 million and section 302.
26/9?
23
Okay. Yes.
Miller.
3 of you.
Miller. As it appears, Miller, there is no eyewitness, Miller.
Yes.
Out of 17 charges, 17 has been examined.
7 witnesses.
7 are already examined, Miller. Not stated anything against the present petitioner.
Out of how many witnesses?
17.
17. 7 witnesses. They are the.
There is no eyewitness.
There is no.
No, Miller. No eyewitness.
These eyewitnesses are these witnesses are what?
Post occurrence witness, Miller.
Occurrence. Where are those evidence?
Well, they are directly involved in that brutal murder case, my lord. Having suspected that the deceased was witchcraft. Therefore, they have unsuspected, they have killed the on the spot.
What?
And the charge sheet,
Who are the witnesses?
well, on one particular statement of 4 witnesses. They all
These-
corroborated the, yes.
These witnesses have already been examined. Out of the 7 which the witnesses, what he says has been examined.
These 4 witnesses have been examined and all stated that the deceased, the second deceased, the wife of the deceased, who also succumbed to, he told that so and so person carrying the kati.
Where are these evidence? Read it.
That is Saraswati Malik.
Yes.
Saraswati Malik.
As PW?
That's PW. May I read that?
What are you reading? 161 statement?
164 statement.
164.
Yes, my lord.
And these witnesses have already been examined.
Yes.
Read the deposition if you have.
Yes, the deposition I have read.
Yes.
That
next to graph. Next week
in all the
You read it.
next week
ଘରେ ପଢିକି ଆପଣ ହାତରେ ଲେଖିକି ପଢନ୍ତୁ ନହେଲେ ହବନି.
next week.
I am sorry,
You try.
51.
51 what happened?
My lord, short date I got.
34.
My lord, I have enclosed the state deposition, my lord, of the informant, because your lordship has directed if the informant examined or 6 months, whichever is earlier. I have given the deposition, my lord, that was in annexure, my lord.
Let them get it as here. Short date is also 51. ठीक. Yes.
Lord, in December.
Yes.
1 week after, my lord.
1 week after. It will go. January. Yes.
55.
Petitioner is in custody, my lord, since 25/9/2023.
25/9?
2023.
25.
Co-accused, your lordship granted bail 4056 of 2024.
4056, huh?
Yes, my lord.
Yes.
That record has come.
Yes.
In that order, para 4, your lordship kindly see.
Para 4.
4. During investigation, the statement
What
of
is your name?
My name is Kunna Dole. Statement which was recorded.
You are reading the state of the bail order of Malisu Patra.
Yes, my lord.
And
Para 4, your lordship kindly see.
This is one accused or 2 accused?
2 accused. The petitioner, another accused, your lordship allowed to go on bail?
No. Bail application I am reading.
One accused, my lord.
What is this? Malisu Patra alias Malisu Patra
alias Senelu Melesu Patra alias S Melesu Patra. One man.
Yes.
Para 4, your lordship kindly see order. During investigation, the statement of one of
Krishna Pradhan was recorded on 164. The said witness is the
eyewitness.
And he is the statement. He stated that Kunna Dole called the present petitioner. Kunna Dole is you. Kunna Dole is you.
Yes, my lord. Your lordship, I have supplied the deposition copy.
Has been sitting in this night and then both of both. You have given the blow.
Yes,
got the blow.
Your lordship kindly turn to flag M. Deposition I have solved, my lord.
Yes.
That witness turn PW 4. That Krishna Pradhan turn hostile, my lord.
Krishna Pradhan.
Yes, ma'am.
He is a child witness.
Yes, ma'am.
But in cross examination, your lordship, para 4.
Para 4.
Yes, ma'am.
Yes. It is not a fact that I have stated before.
He stated that Malisu Patra said that he was with his wife, then was as per saying.
Where are you reading?
The para 4.
Para 4 of the cross examination of Krishna.
Yes, yes.
Hmm.
He said that I along with him went near Maleshwara and Sunil Naik, and after our arrival, Puna Dali assaulted the neck of the Sunil Naik by means of a kati,
Cheap hostile.
for which I became humbled, and both Puna Dali and
No, you are reading. You read the top.
Yes.
Of 4.
on so and so I was.
No, it is not a fact that.
Yes, yes. It is not a fact.
Then what else is there against him? Kunadali. Have you read the other evidence?
Yes, no, I have not.
Say the sole eyewitness. Considering that, your lordship.
As for
See, he has filed the evidence of PW1 to PW7.
7.
Have you read all the evidence?
I have only read that.
Then shall I grant the bail then? No.
Let it come.
You have to read and come. What is this?
Yeah.
You tell what other evidences are there. It is a case of 302.
Yes.
And the allegation is he has given the blow, as a result of which
that
boy died. I granted the bail to the other guy, accused person, because he has not given the blow.
Yes,
he has only helped him for disposing of the dead body.
And that
Therefore, I
witness,
granted him bail.
yes, my lord. Now the said witness turned hostile, my lord. And custody more than a year, my
Let it come next week. I will go through the.
See, you people have to assist me. Otherwise, I'll just record that I am not getting any assistance from State Council. I am granting bail. That's what I am going to write next week. From Monday onwards, this is this. I'll print that sentence, and I'll keep on granting bail. People can't languish jail because of you are non-assistant. Straight away, I'll write that. Be ready for that. From Monday onwards, same thing I'll do. I'll not wait. See, in the earlier order, I have written one of the eyewitnesses has to be examined and he is turning hostile.
That order I have not with me. I requested my learned friend to give you a copy of that order.
Yes.
Next copy of
lordship.
Next week. Let him.
Date may be fixed.
Yes, date.
I may pardon, my lord. Item 10 pass over. That may be some other day. I am absent, my lord.
Some other I'll dismiss. Not today.
Item 10 ta good din ke pass.
10.
56.
Oblige.
56, my lord.
Custody since 21/1/2020. All the witnesses have turned hostile. Pursuant to my lord's direction, the learned ADJ has transmitted the evidence of the one witness. The learned ADJ has rejected the bail application on the ground 2 more witnesses to be examined. My instruction is one witness has expired and another witness has transmitted the witness. That is in the flag.
In custody is 1.5 years. In fact, of the informant case has expired. If bail application is removed, the same condition. Yes. Informant is died, huh?
Yeah, informant died.
Informant is died. And what are the offences?
All the witness.
302 is the offence, my lord.
Yes.
The last occasion, the lordship says 11 witnesses, they have not supported the prosecution case.
Hmm.
And in the rejection order, there are two, page 39, my lord. The court has observed that Srimati Soita Muduli and Genu Sisha was the eyewitness to the occurrence, for which your lordship has directed to obtain instruction, and also your lordship directed the trial to supply the copy of these witnesses have been examined or not. And so far, my instruction is, my lord, Soita Muduli is dead. Now I'm supplying the copy because just now he has.
Yes, Genu Sisa has already been recorded. He has not supported.
Then, my lord, nobody is supported.
Yes. There is nothing there.
But the fact remains, the trial accused statement has been over. And
but what is there? What is there against him? What is the case of acquittal? The 2 witnesses you are relying upon, Genu Sisa and what is that name?
Soita Muduli.
Soita Muduli died. Informant died. And Genu Sisa turned hostile. what else is there?
That is.
Contradiction?
Man, custody by side कोड़िए.
By see?
एक कोड़िए.
Allegations are heinous, but what to do? There is no evidence.
No evidence.
I don't. Petitioner is the accused in so so. Allegation is the petitioner so so. Where is that order?
Last 38 that no.
Last.
The earlier the present petitioner had approached this court. You had approached the
Annexure
court.
3 page 19.
My lord,
Annexure 3
yes.
page 19.
He has approached.
Where is that?
Annexure 3 page 19.
The operating part page 20.
Page 20.
Yes, earlier the present petitioner had approached this court by filing BLAPL number 6438 of 2022. This court by order dated 7/8/2024, while rejecting the bail application as inter alia recorded agent. Para 4 recorded agent. And thereafter, where is that Genusisa?
37 annexure 5.
Impugn order, where is that impugn order? Where does it say Genusisa?
Annexure 5.
Where does it say that Genusisa and who else?
My lord, last page 39.
39.
What's meeting?
The petitioner repeated his plea for grant of bail before the trial court. The trial court by impugn order dated 23/8/2024 has rejected the application inter alia. Where is that?
That is one middle of page 39. No, your lordship, what is 1, 2, 3, 4, 6 lines.
Stating inter alia that
although informant expired and also PW not supported.
stating inter alia that inverted comma, although the informant has expired and the other PWs have not supported the prosecution case, but the eyewitnesses, namely Srimati Sainta Mudli and Gensu Sisa, as reflected in the FIR, have not yet been examined. Hence, the bail plea was rejected, awaiting the recording of the evidence of eyewitness, alleged eyewitnesses, namely Sainta Mudli and Gensu Sisa. The Gensu Sisa has already been examined as PW 14 on 30/10/2024. He has not supported the prosecution case. Therefore, he was declared as hostile. He in his examination in chief had previously stated as under para 2 and 1 and 2. Para 1 and 2. Yes. Mr. Jannah, Lieutenant Counsel for the State on Instruction submits that what is his name? Submits that the other eyewitness, namely what is that?
Soita
Mudli.
Sainta Mudli has since been expired. Therefore, in the present case, the informant and one of the eyewitnesses, had already expired, and the other eyewitness has not supported the prosecution case.
She Soita election, hitting a Soita instruction as it a Soita H.
The petition next door. The petitioner is in custody since 22/1/2020. 2020. Although the allegation against the petition was serious in nature, but during the trial, no evidence as yet has came against him to substantiate to the allegations. Therefore, the petitioner is entitled to bail. Accordingly, he is granted bail subject to condition that the petitioner without fail shall appear before the court on each date of hearing in the singular absence of the petitioner from the trial would entail cancellation of the every day. Once also you will remain absent, you are out. Bail. Singular. Yes.
I'll supply that instruction, my lord.
Yes, sir.
Hon'Ble.
That may be kept on record. Well, just to-
Yes.
57.
I have to go through the CD we have received.
Authority should go through again, someone absolutely there is no allegation against the petitioner. It is a villagers, all the villagers conveyed a meeting.
And pass it over, let him read it.
Yeah.
Pass it over today, I'll take it up. If you are opposing. If you are opposing, then what are the offenses?
302, my lord.
302.
Actually, 302, charge sheet submitted 302, 120B, 34.
302 is there.
Yeah,
You are in custody since?
18/3/2024.
18/3/24.
24.
Okay. I'll take it at next week. Because today may not be possible. Next week the kid read it. You read it and come. Yes.
58.
58 may I please, my lords.
My lord, next Friday. Next Friday.
Next week. Friday. Yes.
Friday.
Friday. Yes.
58 may I please, my lords.
Yes.
First, this on behalf of Mr. Hon'Ble Mati, I may be permitted to appeal, my lord.
That-
My lord,
Yeah, also earlier this case was listed before the Honorable Biraja Prasad Satpathy Court.
my lord,
It
this
was
is a
transferred
tied up
to
matter,
this
my
court.
lord.
Therefore, the copy of that
No, it is not
bail
tied up.
application we
My
should
lord,
not.
here earlier disposed of by this honorable court in BL appeal number 13597 of 2023.
Earlier disposal. Yes.
Yes,
My lord.
the copy of that bail application
Copy.
is not with.
My lord, in that order, my lord, order dated 1/8/2024. The lordship may just paragraph 4 of that order.
That's it.
Siraj, thank
Yes.
you. My lord, second line. However, I give liberty to the petitioner to renew.
Show me the independent witness.
My lord may come to Annexure 3, running page number 11. Yes, turn out.
Yes.
And the petitioner is in custody since, my lord, 22/3/2023.
It's all right. Read what are the evidences.
Running page number 11, my lord. I do not know the informant excise officer.
How many witnesses are there?
My lord, 2 witnesses are there. And my lord, section 100+4 has not been complied in this case. And my lord,
Independent witnesses.
only one independent witness is there. And he has turned hostile, my lord. This is the entire case.
Show me from the charge sheet.
My lord, charge sheet.
Everything in the court only, throwing papers on the court. Not putting anything on record.
I may be pardoned to that.
This has been a practice. That's the whole difficulty. You keep it with you. When something is asked, you take out something from pocket and give it to the court.
I may.
What kind of practice this is? I don't understand. Place these things on record.
I'll place it, my lord.
Don't have that kind of practice, please.
My lord.
This is High Court. It is a court of record. You have to place everything on record.
My lord, I'll place that on record.
I rely upon something you give it. I don't know whether this matter, this paper is related to this case or not.
My lord,
I don't have time to coordinate things.
I may be pardoned,
And you give everything from the pocket.
my lord, inadvertently, the wrong document has been annexed.
Inadvertently, once it happens, then inadvertently. In every matter it happens, it can't be inadvertently. This is a practice. And now we are going by this paperless court.
My lord.
We don't have file. If you give some paper, I rely upon it and throw it. Thereafter, somebody else will move an application. Where from you got this thing?
I'll bring that on record, my lord.
And if it is challenged in the superior court, and this entire record will be taken,
my lord,
and the superior court will say that where from these findings are recorded. Nothing is there on record. And I record so many findings on the basis of the statement made by the counsel. This is not the practice. Place everything on record so that immediately we can decide.
My lord.
Yes.
Next week, my lord, your lordship. Next week.
Develop that kind of practice, that exhaustive petition with all evidence and everything, so that it is easier for disposal. Yes.
Maybe pardon to that extent because
Yes, file it. Whatever you want to
file
relate.
it, my lord. Because in annexure 4, running page number 14, instead of the C5, my lord, C4 has been annexed. That is the sole difficulty. I'll bring it on record. my lord.
Whatever.
I may be pardon to that extent. Next Friday, my lord. Your lordship.
I'll take it up for the other matter after you declare.
I'm grateful.
Item 69 million.
Yes.
That compromise is going on. Offenses are by private magistrate, family dispute. I say after vacation, my lord.
Okay. 69 after vacation.
Let's say,
Interim order may be there.
let's say item 71, let's say.
This is 69, sir, 69 is 2016 matter.
69.
No, 2016 matter now you are saying.
That compromise is going on, my lord. That is why I kept it to, I am the petitioner. Somebody has told.
No, it's all right, but you have taken stay, enjoyed for such a long time. Now you are saying that. What are the offenses?
All offenses are private magistrate, but family dispute. Dispute between.
All are compoundable offenses.
Yes,
Go there.
On next date, my lord.
Friday. These matters are unnecessary troubling us.
Because,
Friday.
Take some time to compromise.
Then I'll vacate this day.
No, then 5 days or so.
Yes.
Let's say item 71, let's say my senior was.
Friday. It's made clear.
Let's say
it's made clear that no further adjournment shall be given in this matter and under any pretext.
Let's say item 71, let's say my senior was requested to post this matter to 18 December. Let's say unfortunately list this matter today.
2016, same story. I'll look into it. I'll not give. See, these matters are all frivolous cases. If you taken stay and enjoying from
Let's
here
say my senior was nephew.
let me see if you have a case, then I'll definitely do. Otherwise, I'll vacate this day. Vacate this day. I'll just check it out. These matters are unnecessary pending. How many days can I tell you?
That's 70.
Just count how many days you have taken adjournment. This year only 3-4 times. I'll see. I'll see all the matters.
Eight zero.
80.
My lunch sister, she was here during lunch hours. She got a telephone call, immediately rushed to me, saying that her mother fell down, some fractures.
Okay, 80 urgent.
She rushed. So, any lordship, I fix any.
Yes.
Let's say item
That's not difficulty.
Let's say item 71 and 74. Let's say my senior's nephew's marriage today. Dharan sir.
Very nice. That's correct.
Marriage.
No, he tried otherwise. I said no. Now he thought of how to get there. And now he is he used this occasion.
And we too also extend solidarities. Because
So morning he mentioned, I said entry order there I'll not.
without substantial grounds.
So he thought during lunch and he thought this is the best way of
71 and 74. Both are interim orders.
Interim orders are there. Short before vacation, try and give it. First week. Yes. So you are successful somehow. Yes. Yes, sir.
Right. When I was not there and when matter called. But here I have paid for passing of the proceedings. And I have annexed the statements given by the victim, father and mother before the learned court below. And to you.
This 376.3.
Yes, fellows.
Notice has to go.
No, my friend has already appeared.
Yes. You are appearing. This is for quashing.
Quashing, madam.
Yes.
After statement, the statement he has said not hostile. He has denied. Her father has also denied. There is hostility between the two families, and the mother is staying 10-12 years. Is staying away since last 10-12 years.
So yeah, your case is no evidence has come on record. Then what will happen, you know that?
My lord, there is every presumption, I may not. What is really happened? In the meantime, the lady has married.
You just answer me one thing, legally.
Yes, Lord.
If the evidence is recorded,
My lord.
right or wrong, something has come or something has not come. Evidence is recorded. And trial is going on. At that stage, 482 court will go into the merits of and
Not exactly
evaluate the evidence and say that
not exactly merit, because going to merit is also adjudicating. Taking in the cue from the present scenario.
Then you are saying settlement.
Yes.
Then you have to bring them. That's the only way of doing it.
Yes, yes.
You don't rely upon the testimony of the witnesses.
Testimony at least to suffice my bona fide.
To satisfy that you is a case of settlement. Bring them. That's the only way.
My lord, my predicament, I have married in the meantime, so much.
Whatever, I don't know. Because
what my friend is saying, if she has married at Sunaveda, if your lordship permit, she can come to the virtual arrangement at Koraput.
You can do that, no problem. You can do that. You can do that.
My lord, I am living happily with my new.
But I can't be a party to that. I can't give directions to the because see, what what will I do then? See, the evidence has come. The evidence according to you is not suffice for the purpose of conviction. Then you have to move appropriate application for dropping of the charges and close the. That's the best way of doing it. I think it is very CRP. 323 or what is that?
Stage nahi.
My lord, may can I fix one date? My lord, may can I fix one date so
that may be cumbersome little, my lord. No,
not cumbersome. I'll just show you.
After the discharge stage, I think subject to correction as your lordship.
No, I'm saying something else. Where is that provision? I'll just look at the provision. There is a specific provision. Where is that? Well, I'll examine that. I'll just issue notice, let us see. Notice has been issued, so and so entered appearance for opposite party member on advance notice, on advance notice. Mr. Das, land counsel for the petitioner submits that the opposite, the victim as well as the informant has not supported the case of the prosecution when they were examined before the court. So taking the clue from the said judgment, he says that the parties have settled their dispute. Hence, he seeks indulgence of this court under the inherent jurisdiction under 482 CRPC for quashing up for the same. So and so entered appearance on advance notice. That further submits that the parties would appear before this court to reiterate their stand. Least the matter also. Yes. Bring them. We'll see.
Item 25.
Can I make a small prayer again? Can it be before the test?
If you can bring them, put it on 23rd, 23rd.
Grateful, your lords.
Yes. Yes.
May I please, brother? Rak Shakti matter is similar. Without sanction, the learned special has taken cognizance of the offences. This is the crux of my method.
Yes.
Synopsis. On the my lord, I have my kindly glance to page 7, paragraph 2. For that, a person cannot be removed by the employer while in service. So
What are the offences?
My lord,
Offences?
offences 13 reduction 13(1)(e) of the PC Act. DA case.
Okay.
DA case.
Yes.
But the
I choose to work with the Disney Cruise Line
in
because it's the
in
best
grounds number
company
2,
in the
3,
seven
4,
seas. No
I have
question about
mentioned
it.
specifically on the date of how such he was in service, on the date of charge sheet he was in service, on the date of the Lord Special that taken cognizance he was in
I
service.
got an opportunity to sail with
I had
Disney,
filed a discharge
and
petition.
it was absolutely
The
like
discharge petition was
once in a lifetime experience for me. I absolutely love my job. I wouldn't trade it for anything else in the world.
Yes,
This is that matter,
No,
your lordship permits.
Not in the same post. Is that the case?
The another ground is also there, but your lordship is correct. No? To refresh your lordship, Mary Muller, that the post abused was a section of the post. Thereafter, in a department proceeding, he was demoted. At the time of taking cognizance, he was in a different.
He was not
post.
holding that post.
Yes.
Or a superior post.
Or office.
Or a superior.
Because
Yes.
the reference before the Honorable Supreme Court.
Yes.
I'm just placing one line. What was the point referred for? Whether a public servant who is not on the same post, here the case as a post, and is transferred, whether by a promotion or otherwise to another post, loses his protection under section 19(1) of the PC Act, though he continues to be a public servant on a different post. Now, well, he was.
What was the judgment then? What does it say? This is the question. What is the answer?
The answer is not.
Not necessary.
The answer is.
Can I get the judgment copy?
Yeah, let's see.
Yes, please.
And that apart, my lord, I've got another small point also, my lord. If lordship is satisfied this one, my lord.
If there is direct judgment, where is the question of not satisfied?
The lordship, that's why I will indicate the lordship. Lordship turn to.
It's all right. You have.
Lordship turn to the 1 minute. That's meant for the lordship, my lordship.
Para 21.
Yes, para 17, my lord, is the question frame.
Yes, which we read it out.
Page 608, my lords.
Yes. Now come to 21.
21, page 611, my lords.
It's clearly. It is.
Page 611. This is 11, your lordship, in paragraph 21, in middle portion, my lord. You got lordship. Para 21 middle parts. However, one discerning factor which is to be.
Judgment.
No, my lord. My lord knows better than me.
No, I know. I don't know. I am.
No. They better than me.
Do you have any judgment after 2016?
My lord.
After 2016, do you have any judgment?
No, my lord.
Contrary to the view taken by the Supreme Court.
I'm satisfied, my lord. The Tyler versus Tyler case, once statute states on the date of taking cognizance, he was in service.
You think of Narayan Swami, why are you taller, where are you going?
And
Narayan Swami.
Narayan Swami judgment, I cannot say, but the judgment has not gone. Since Act will not supersede the decision. The Act, certainly the Act holds. Section 19 speaks on the date of taking cognizance.
19 was interpreted by Supreme Court and said that if you are not holding the same post on the date of cognizance,
no prejudice.
No sanction is required. That's what I just read it.
But
page
the,
21.
but the Toiler versus Toiler case and the interpretation of statutes, Nazir Ahmad, that the Act says sanction is required, section 19, but the judgment does not hold good. Yesterday, I was searching for.
Have you read this judgment?
I have read, my lord. Interpretation of statute and other judgments.
May not be bereft of that, but Lordship, turn to the second point. Lordship, turn to page 34 of Lordship, brief, Lords.
34.
34, this is the portion of that imbue orders.
Okay.
This is also important, man. Here also there is no escape route for him. Page 34, I hope you Lordship got it, Lords.
Yes.
On the other hand, Lordship, skip all this thing, Lords. The fourth lines. Sambapur by the order dated 31/1/2004 directed for reinstatement of the accused by modifying the order of the Collector Burgard, and the copy of the said order was sent to Collector Burgard for necessary action at his end. Now the important line starts. A copy of the said order was served on the accused only on 29/2004. I take a poach notes. The cognizance in this case was taken on 20th May 2004. The cognizance was taken on 20th May 2004. And a copy of the orders of a reinstatement were received by him on 20th September 2004. Notes. And the accused also acknowledged the said receipt of the order of RDC Sambalpur by putting his signature on the first page of the said order of the office copy of the order, which clearly proves that till 20th September 2004, the accused was not in the government service.
This is a contract, manner. Joining.
Don't go in merit. You sanction, you have no point, sanction, forget it. Now on merit. Sanction point, you forget it now.
The sanction point.
Sanction, you don't have it.
The sanction point, Narayan Swami case.
First of all, you were not on the service when the cognizance was taken. Cognizance was taken on 20th of May 2004. And you have been reinstated in September 2004. At the time when the cognizance was taken, you were not even in this service. Forget about the other.
My lord, on the date of cognizance was taken, I was in service.
You received that reinstatement orders with the signature on 20.
Anyway, but not in the same post. Even if you were there in the job, you received subsequently. That fact remains that you are not.
The order was passed earlier, but the collector, the order of the collector was set aside by the RDC. The order was I have quoted. The Toiler and versus Toiler case, it's section 19.
Toiler has taken a lot of turn thereafter.
Knows better than me. I would then have to say point over research.
Yeah, you have today he considered that he doesn't have a case.
No.
So he's taking energy.
I pray one thing. At 2 p.m. any day, my lord.
Not what 2 p.m. it takes only 2 minutes.
2 minutes any day, my lord. At research research.
Research. Don't bring Taylor, huh? Taylor will not help. No.
I pray one thing, my lord.
If you don't have anything, then you start interpretation of statute. Mullahs and and all this stuff will not help.
That is why I pray one thing.
There is a specific judgment of Supreme Court in Narayan Swami, then you have to deal with it.
No. Narayan Swami case in one para 17 case stated, there is abhijog process. That case,
then you have read it, argue it and finish it up.
No. Narayan Swami case, it is misuse of abuse of power. But here in this case, I have not been abused.
Then that is again on merit.
No. I am searching for the judgment. I pray one thing, my lord. If my lord permitted, in evidence, I have in one per state I have taken sanction. In another pair, I have not taken sanction. That is point of arguable point. That's what I'm searching. My lord, the trial court has posted is 21st.
21st of
December. I pray, my lord, first week January also, in the meantime, adjournment percent.
No. After having satisfied that you don't have a case, why should argue this? Come tomorrow. Come tomorrow.
My lord, if a lordship
I have heard it, I understood it. Why to waste time?
If a lordship permits, may I take 1 minute to pursue my lord friend, my lord? It's of observation, Roy. Why take the risk? Withdraw and get the leave to raise all those points.
That's a better idea. Tomorrow, huh?
No, withdraw now. I will think of
next week. Friday.
Next Friday.
Ye Friday. Coming Friday.
Monday, Delhi matter.
Okay, Friday.
I wish you safe journey. I wish you safe journey.
Safe journey, safe earning also.
So blessed.
Yes.
59.
5 years.
No application and limitation is there. Another application is 59.
302 and other 302 also. Sit is with me.
Yes. Are you ready? Yes, 50. 50, nobody is there. So none appears for the petitioner in the interest of justice, January. Yes.
On behalf of permitted to raise the matter, the
Yes, sir.
review on behalf of Mr. Jana, my associate. This case, a review petition is there with some limitation. Two application I want to place your lordship. That is.
What is the extent of delay?
Delay is 2 years. 2022. That is date of judgment is 25/7/2022, and it is filed on 18/7/23. 1 year something.
Delay of
1 year something, I think.
Yes. What have you explained? Nothing.
And another first application, I may pray your lordship. First application is that is required because 424 is
in the condemnation of delay application.
Condemnation of delay another application is required to fast take up because
sorry,
another application 47420 IH 424/24. Lordship may take up fast because respondent died in between the judgment and filing of the review application. The LRs of the respondent must, that was the office note defect. Or lordship will you issue.
Who are the LRs?
LRs are the LRs of the respondent, sole respondent, Marpodar.
Okay, that I'll allow, but what is the what is the explanation?
Explanation is with regard to that section, say DT property. With regard to merit of the matter or delay, lordship putting my question.
What is the explanation of delay?
Delay is that my father also died. My father was contesting the respondent.
Yes, who is appearing?
No notice has to go.
I'll issue notice in both the application of delay as well as an issue notice on the application as well as the review petition. Here, we'll see.
Both
Yes,
application,
next.
huh? Both application, another.
Yes, both the application. Both the applications. Issue notice on applications as well as the review. Yes, next.
State execution file karo, thereafter I came to me.
What state?
Notice out.
So all the applications.
All the applications notice. Yes. 3 application notice. Register post.
Yes, 60.
Like it.
Restoration. The delay, how much delay? Then you settle it. Unless it is restored. What is this case about? MSCT
appeal against the MSCT award, insurance appeal. We have settled the quantum and we will place in the local adalat.
Okay.
Coming local, simply it will be restored and your lordship directed the
an application for restoration of the MACA,
Yes.
MACA number 411 of 2020, which has been dismissed on 11/12/2020 for non-prosecution. The present application is barred by limitation, and barred by limitation. The petitioner has moved application IA number 548 of 2024, explaining the delay of how many days?
1,361.
1,600.
1,361 days.
1,361 days. Although the explanation offered by the petitioner in the applications are not satisfactory in nature. But I'm inclined to condone the delay only on the ground that the parties have settled their dispute. Once the appeal is restored and referred to the litigation, the same could be put to rest. Let counsel for the opposite party on advance notice has appeared and also joined with the present petitioner on the prayer for restoration of the appeal, restoration of appeal. Both the council conjointly submits that the appeal may be placed before
Coming Lok Adalat.
coming Lok
14th.
Coming Lok Adalat on 14th, as the parties have settled that issue. Parties have settled, restored the appeal. What is that appeal name?
MSCA.
MSCA number so and so to its original file, and least the appeal before the Lok Adalat on 14th of December. National Lok Adalat on 14th December. Yes.
61 I was supposed to appear for the informant due to accident, but I was not able to reach. The road was blocked. Can it be taken up on Monday? Because
Matter of compromise between the parties.
What are the
506, 294,
53,
48?
506.
or लगा देना Monday Tuesday.
Monday रखे थे, मैं appear करूँ.
62.
Obliged.
Well, it is a compromise matter, but the OP is very seriously ill, and that is why he has not been able to attend.
Okay, urgent group. What are the offences, by the way?
207 matter.
Huh? What are the offences, sir?
Offences, my lord.
What are the offences? You have
341, 345, 345, 506,
Chalo, 323 and all. Yes, no problem. Urgent. Huh? Yes, notice sufficient. The other side will come and appear.
My lord.
Bring that.
May I be lordships? Here, my lords, the petition challenge the casting of affair, my lords. The offense is, my lords, 399.
Even the there is the charge sheet should have been supplied. No charge sheet has been supplied.
No, what are the grounds? Investigation is over.
My lord, charge sheet has been filed, my lords.
So what are the grounds?
The grounds is, my lord, petition is the juvenile. It is
Juvenile ground.
And the second thing, my lords, he is not in the spot. On the
All these
basis
things,
of
all these
cooperating,
things said, you have only filed the copy of FIR.
my lords.
You want me to go into all these things?
Charge sheet is there, my lords. My lord,
I'll just dispose it up.
399 and
Petitioner is seeking quashing of the FIR, FIR number so and so for alleged commission of offence under section 399 402 402 IPC. After investigation, charge sheet has been filed on. Charge sheet filed on.
1912. 2020.
Give it to me. Give it to me.
My lord.
No copy has been provided.
A charge sheet has been filed on 28/4/2023 for alleged commission of offences punishable under section 399 402 IPC reduced section 25(1) capital B and small b and 35 of Arms Act. Counsel for the petitioner submits that he would reserve his right to hesitate all the issues before the trial court at an appropriate stage, and with this liberty he seeks to withdraw the petition. Dismiss as withdrawn with liberty as prayer. Yes, next one.
Allah, I am a prayer, my lords. And NBW is issued in this case, my lord.
Where is that? Tell me.
No, it's charge sheet is transferred.
Charge sheet.
Last.
Don't
Give it
appear.
to surrender, my lords.
ये item कितना है?
Last page, my lords. 63.
This is counsel for the petitioner further submits that the charge sheet has been
Last
filed
person.
against the petitioner, showing him as an absconder as a result of which NBW has been issued against him. He, on instruction, submits that his client would appear before the court on or before 30th of December and seek the appropriate remedy available to me under law. Subject to petitioner appearing and moving appropriate application for grant of relief. The NBW issued against the petitioner shall not be executed. Hmm.
64.
May I please, Your Lordship, Lord?
Yes.
But hearing Lord, Your Lordship was kind enough to direct the opinion number 2, the ban. A notice for us made sufficient.
Notice let us give one more opportunity. Notice on opposite party number 2 is sufficient. However, non-entered appearance and in the interest of justice, one more opportunity is granted. Please the matter.
But if any interim order was there, that
There is no interim order, it seems.
right?
There is no interim order.
Oh, then we'll the post cognizance stage have come up. We'll make an application if necessary. I will make an application for
service organ by nobody. Service is complete, not coming for application.
Oblige, Lord. Last time.
65.
My lord. Question of criminal proceeding, more than 25 years has been passed and FIT has been submitted below.
24.
25 years.
When the FIR was registered?
99 below. Annexure 1.
Charge sheet has been filed.
Yeah, FIT. Yes, below.
No, charge sheet has been filed. Charge sheet filed in 2000.
Insufficient of evidence.
2000.
Yes, below.
True.
And
cognizance is taken.
Cognizance taken 2013, charge 2024. And in between, my lord, Honorable High Court, my lord Justice A.K. Mahapatra granted two times, 6 months, 6 months to conclude the trial. Nothing happens. And here in this case, this petitioner, 16,000, that allegation, that subsidy amount misappropriated, that has not yet been released, my lord. That is their own admission. Charge sheet. So nothing. Then 4 years, your lordship may see that Amendment Act, the said period may be extended by such further period for reasons to be recorded in writing, but not exceeding 6 months at a time. So, however, that the said period together with such extended period shall not exceed ordinarily for 4 years in aggregate.
What is your name?
My lord Ashutosh Behra. Your lordship may see 16,000 16,100 टका subsidy आज पर्यंत sanction नहीं as per annexure 10, your lordship may see that. ସେଥିରେ ମୁଁ prosecutor ଯାହା against ହେଇଥିଲା ସି ତାର ବି charge sheet ହେଲା ମୁଁ ହଉଛି executive authority ଖାଲି ମୁଁ ଦେଖିବି pipe insertion ହେଲା କି ନାହିଁ annexure 10 page 45 lordship may see subsidy not released and SPC report lordship may see SP भी से कथा कहले annexure 6
Who had filed the writ petition? Number 7.
One of the co-accused, another engineer has filed. 6 months time diya. And lordship see, I have prepared a written note, lordship, with citation. 2007, that was passed by the coordinate bench.
You want to take advantage of the order of writ petition filed by co-accused. Filed by co-accused.
Yes, my lord.
But why don't you think one more thing? The other co-accused person is absconded as a result of which the trial is delayed.
My lord, that's why 22 दिन delay. That I have given. सब जगह order sheet you have change जो कहले.
No, I have got a report from
yes,
the
exactly. Lordship last occasion directed me to file objection to that report. I am just pressing that objection, your lordship. May see. मात्र 22 दिन देरी है. ये जो NBW issue वाला not against us, my lord. Two contractors. Only 22 days, my lord. I am coming to.
Yeah. What is his name? The trial was about to be split up.
Yes.
And
No, 22 days only, my lord. Those split up 22 दिन मात्र. That is the order. Order also I am
It is
annexing.
after completion of the appearance of all the accused, above named accused persons, while the record was posted for consideration of charges, the same could not be possible
Lordship may
due
see
to
this order.
physical appearance of all the accused persons. One
That-
person
that is
goes,
what-
another person doesn't.
My
come.
lord, that is for 2 persons, my lord. সেটা মাত্র 24 দিন দিলে।
So what do you want now?
My lord, ମୋ against କିଛି ନାହିଁ। Already 25-26 ବର୍ଷ ଗଲାଣି। ଆଉ ସେଠି ହବ କଣ?
Yes.
That's why they denied to file an objection.
Upon now, it will be adjudicated in the trial.
Now, why so much of delay? That
Delay is attributed to the accused. The report says.
My lord, against that report.
And another aspect is.
Now, why investigation is delayed?
Investigation.
I called for a report from district judge regarding the proceedings,
My lord.
which has taken place after the charge is framed. But what happened? To 99 is FIR.
Yes.
You filed 2000 charge sheet you have filed. Thereafter, what had happened?
Thereafter, the court transfer ହେଇଛି case. ତାପରେ ସେ କହିଲେ ଯେ they did not accept the report. Thereafter, cognizance was taken after submission of that sanction or other materials. Now, after cognizance, some of the accused approach dishonorable.
Cognizance is taken in 2013.
13, my lord.
Yes.
Approach dishonorable. And it was delayed here. And some of the accused remain absconded. But some are rather they are responsible. 36 years ପରେ ବି Supreme Court କହିଛନ୍ତି ଯେ ନାଇଁ PC Act offense it cannot be tried. Cannot be.
That's right.
So another opportunity will be that learned trial judge has seek time and trade for some time as a last opportunity. It should be happened
Of evidence in
in the interest of justice.
Wherever this court to take all the protection. No stone unturned to dispose of the case as early as possible. Therefore, request to itself place the matter for the yes. The trial court is seeking some accommodation.
Yes, my lord. I am just, my lord, have a glance to this. Paragraph 78. I am giving the objection to that report, your lordship. The status report dated 31.
You filed it?
Yes, I am filing. I am giving copy also.
You file it, give it. Yes. File.
Copy.
Next. 65.
66.
But I cannot file it in court.
No.
Lordship, next week, my lord.
We'll keep it.
Petitioner's son was murdered. The protest petition mini trial has been held. So last occasion, Lordship was pleased to issue notice to the accused, my lords. They are somehow avoiding. So, your Lordship, if they can, if the state can inform them.
Through opposite. Who is the opposite party number 2 now?
Opposite party number
3. 2.
3. Opposite party number 2.
2. Okay, 2. Opposite party number 2. Despite notice of none appears for opposite party number 2. The IO of the case. Which police station IO is that?
Capital police station.
Capital Bhubaneswar, huh?
My lord.
Capital police station Bhubaneswar. I directed to serve the opposite party number 2 and place a report before this court by next date of hearing. Yes.
7.
Your lordship.
Telling for the copy number 2.
Yes.
Why?
Yes.
Here, there is other copy, but so far, my verification on my verification, it is seen that the petitioners of the petitioner, the criminal message, they are sought for the quashing of the charge sheet. So in that respect, I have filed also protest petition there before the London court below. If your lordship will allow their prayer for quashing of the charge sheet, let there be the investigation with supervision of the higher rank officer, then everything will be survived. And I will not.
Why 498 and all? Why are you not settling?
They are not settled. They all from the initial effort. They have now they are taking that advantage that why did not I report the matter when I was initially assaulted. Waiting for the good time, I did not lodge any report. And now that advantage they are taking that at that time of assault, there is no injury, that time of assault, there is no FIR. after 6 months, this FIR.
Generally, immediately no wife goes and
The wife has
wait
not
for.
Even as of today also, the in-laws are not ready. They are
Yes, madam. Why don't you settle your inviting problem? She has filed a protest petition. I can't quash it because then whatever argument you want to develop, you go and develop that. I can't help it.
Your Lordship may kindly fix another date. I will take instruction from my senior. Actually, I thought that the requisites are not received by the opposite party. So I'm here to.
I have not received the notice. But for the information, because in the DVR, they have given that we have challenged. So on my
So
query.
Mr. Mahapatra enters appearance for opposite party number 2.
So your Lordship, shall I again file the requisites or?
No, you need not. She has already and filed Vokalatnama and copy of the petition we supplied to Mr. Mahapatra. This is the matter. January 1st week. Yes, January.
70.
January 2nd week. Yes.
Your Lordship, last occasion directed to both the parties appear before the mediation.
What
Like
happened?
mediation failed. जहाँ आगे कहले से टंका दवा को गोटे फ्लैट मागिले आउरी 6 लाख टंका मागिले भुवनेश्वर एरिया रे फ्लैट and in the meantime divorce already been granted and appeal confirmed and permanent alimony mallet already deposited. They are disputed. I have not deposited the permanent alimony. Your Lordship kindly see the document.
Yes, sir. After getting permanent alimony and all.
That is, we are not disputing that. For convenience of the court, I am submitting a date charge, Lordship.
No, then it has to be argued. Right. Mediation, the matter was referred to mediation. However, the mediation has been unsuccessful. Leaves the matter for hearing. Interim or to continue. February. Yes.
72.
You want to fight it out throughout life, fight it out. No. Interim February last week. Yes.
72.
None appeals for the petitioner in the interest of justice shall be March.
73.
Yes.
Lord,
Yes,
there is
sir.
a case, your Lordship has given a direction to that, Lord, the shop was obstructed by putting on a lock, and the public, the shop and the public, Lord, they have given ornaments, they are kept in the shop room, and my ornaments as a owner. So, public equity is a fundamental right that has been obstructed by the opposite party. The first court, that means the court at the first instance, granted direction for removal of the obstruction. However, it was overturned by the higher forum. Thereafter, your Lordship has come. So, in this short point, your Lordship has given direction to notice to be served through police, and it has been served, not come.
Yes, madam.
Then that's how it will. Your Lordship's direction to make them party, and that has been superseded because your Lordship has given direction to make sufficient service.
No. Through IIC Kendrapada,
Yes.
I told.
Sorry, sufficient your Lordship has already held. By the order dated 7/10/24. Your Lordship's direction order.
The notice of opposite party has been served.
Yes.
So
that was the. No.
Yes.
The order uploaded.
Yes. The service is complete.
Yes.
You've done.
A short point. If they are not coming, that order of the maybe complaint order. The order which was given removal of the was there. That maybe.
She wants to get something.
Yes.
I'll
Come,
visit it.
coming.
Yes.
Yes. Positively.
Give a copy because yes.
76. 75.
Our matter is 75. That students matter.
Anybody ask for adjournment?
Yes, my lord. That good school student, they have make us.
Well, they didn't have any locus now. They are the informant, that's why I implemented the party. But let's start, let's with the state. If state
Who has asked for adjournment?
this informant might have, he requested me.
Showing that very senior advocate is circulating.
Yeah,
That's the whole
unfortunate.
problem. Very how will
Very unfortunate, yes.
Here, is appearing on behalf of the opposite party, both the second.
Because he's informer, now he is the president appear kari I don't know. So sir, there's Lucas is gone, there's stand is
No, what had happened in
Follow
this
the
case is,
stand
the informant in the court said that, no, I don't have any problem. And now when this petition is filed, a senior counsel is coming and opposing. Taking a completely contrary stand, then the stand which has already been taken. Anybody is there? You are appearing for whom, sir?
My lord.
No, you are there?
No.
You are
What I am saying, my lord.
I'll put it tomorrow.
Yes.
No, nothing doing. You tell him.
That's minus 6 to 24. That's the.
Huh?
That's the minus 6 to 24.
You tell him Monday, Tuesday, and tell him. See, this is unfair. But if you are mentioning, if some main counsels are not there.
He asked me, I told that I am coming to the court. You will mention, you submit.
See, what
sort of practice is such a senior court?
At least you tell all these things. You just intimate that I have preponed the date.
May I pray, my lord, if he.
Wednesday. Tell them 24th I have kept.
May I keep it 2 p.m.
Yes, 2 p.m. No.
2 p.m.
Make it 3 p.m.
3 p.m. Yes.
3 p.m. And tell, please.
Yes, I will implement this.
I'll suggest you one thing. Please write a letter.
Yes. This I mentioned and the court has specifically picked to.
And it, behind my back it was mentioned. So on the turn when the matter was taken up, this has transpired.
Yes, yes.
So put it in writing and give it to me.
Now this time has come, I will force to adopt this Supreme Court system.
Yeah, that we do like that.
You are doing this.
We have been doing like that. That's the practice there.
Yes.
So everything is on record and it is put.
Apparently, this letter is better. Always it is.
If somebody comes and mentions and takes a date, immediately we write a letter that behind my back it has been mentioned. I have intimated to you and matter is now listed and satisfied. The oral business will not.
Justice Muralidhar adopted, they started adopting this.
That is the real practice.
Yes.
And you say something, I don't know whether you will inform or not. And Wednesday the matter will be taken up and on 24th he'll come that Mr. Padi is not told me.
His associate requested me, on your request, we have postponed to Saturday to Friday.
Okay, right.
He will come to the court. And 2 p.m. I will virtually appear here or I will see. Simply I will come and take time.
Write a letter.
Yes.
Yes.
Let's keep it to Wednesday. 3 p.m. Obliged.
76.
Yes.
I have already filed the joint affidavit. Matter was amicably settled between husband and wife. Both are present.
What are the offences?
376. 376.
Okay.
Page 19.
He got married to the same accused.
ଆଉ ବାହାଘର କାର୍ଡ ଟା ଆନେକ୍ସଚର କରିଛୁ 19।
Where is the girl? Call the girl.
Both are present.
Call the girl. Ask. Niranjan Parikh. So entered appearance for opposite party number 2 and seeks 1 week adjournment for the purpose of filing response to the petition. 1 week time is granted. Please the matter on. Yes.
78.
May I please, your lordship? Lordship, the petitioner challenged the cognizance order dated 16/6/2020, my lord. On the last occasion, notice was issued to the opposite party number 2, my lord.
Service notice. Service on opposite party number 2. So is already service on opposite party though is sufficient. None entered appearance on behalf of opposite party. In the interest of justice, release the matter on session stay interim order to continue. Yes.
79.
My lord, interim order may continue, my lord.
Continue. Yes, sir.
Last on the previous occasion in the case, notice has been issued to the respondent. And the notice made sufficient.
Might have somebody appears, but nobody is there.
Nobody enters appeal.
Yes.
Notice on opposite party number 2, although is sufficient, but none have entered appearance on behalf of the opposite party number 2. Hence, in the interest of justice, last opportunity granted to the opposite party number 2 to appear in the matter and appear in the matter, lease the matter on Sunday, interim order continue.
Problem.
80. Okay, thank you.